Welcome to the fifth hearing for the inquiry into acquisition of land in relation to major transport projects. Before I commence, I'd like to acknowledge the Gadigal people, who are the traditional custodians of this land, and I'd like to pay respects to the elders past, present and emerging of the Eora Nation, and extend that respect to other Aboriginals present and those who may be watching online. Today we will be hearing from a number of stakeholders, including government officials, local councils and legal representatives. While we have many witnesses with us in person, some will be appearing via video conference today, such as our first witness. And I thank everyone for making the time to give evidence to this important inquiry. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. The transcript of today's hearing will be placed on the committee's website when it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. If witnesses are unable to answer a question today and want more time to respond, they can take a question on notice. Written answers to questions taken on notice are to be provided within 21 days. If witnesses wish to hand up documents, they should do so through the committee staff. In terms of the audibility of the hearing today, I remind both committee members and witnesses to speak into the microphone. Finally, could everyone please turn their mobile phones to silent for the duration of the hearing. So I now welcome our first witness. Mr. McLaughlin, if you could start by stating your name and position title and then swear either the oath or the affirmation.
Thank you. Stuart McLaughlin, Executive Director in the Property and Place Group within the Department of Planning and Environment. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. Mr. McLaughlin, did you care to make a short opening statement?
Yes, that'd be great. Thanks for the opportunity to assist the committee here today. I'm looking forward to explaining the good work that the Just Terms valuation team have been doing at this busy time. In preparing for this hearing, I've reviewed the transcript of the proceedings on the 18th of February. There are a number of questions at that time about the interactions between the Valuer General and staff on a personal basis. I'm really keen to make sure I assist this committee and provide all the evidence I can. Questions in relation to aspects of the interaction between the Valuer General and some staff will necessarily include personal information that's protected by law, may involve protections for people making complaints, and likely also the expectations of people that these matters are addressed confidentially.
Okay, good.
I'd like to ask the committee's understanding that if the committee will be asking questions in relation to these matters, it is likely that I'll need to take them on notice in order to ensure I comply with those other obligations in answering.
You can go on camera.
Thanks.
Understood. Thank you. We'll commence with questions from the opposition.
Thank you, Chair, and thank you, Mr. McLaughlin, for your attendance today. It's Daniel Mookie here. I wanted to first just understand a few very basic questions. You are the Executive Director of the team inside the department, that's correct?
Yes.
How many people are in the team?
Depending on staffing and contingent workforce, it may vary, but at present, for Just Terms valuations, the amount of staff would be around 10 people.
Around 10 people, and practically you work in, or you are attached to, the 10 people are attached to the Office of the Valuer General, is that correct?
They're attached to Valuer General New South Wales, which is the department's agency.
Yes.
Name.
So,
yep.
The employment relationship of the 10 is with the department, but the practical nature is that they are attached to the Valuer General's office to perform the valuations that they are required to under law?
Broadly speaking, yes. So that team is essentially employed by the department to provide services or functions as required by the Valuer General.
And they are not direct employees of the Valuer General anyway, that's correct?
That's my understanding, yes, correct.
And so the employment obligations, including the obligation to provide a safe workplace, belongs to the department. You agree with that?
Broadly Broadly, yes. Yeah.
And of course, the Just Acquisitions team is 10 out of about, 220 or 240 people who in general work for the Valuer General's agency?
No, so Valuer General New South Wales would have about 100 full-time equivalent employees, but there would be a varied workforce, whether they be contingents or contractors.
Okay, thank you. That's helpful. The committee has heard evidence, in this proceeding and I guess in other proceedings of the Parliament, that a direction was issued to the Valuer General to channel all his communications through a executive director, and that is that your understanding as well?
Yes, that's my understanding. It obviously occurred before my tenure with Valuer General New South Wales, but yes.
So can you give us the department's views as the arrangements as they currently stand today?
In my opinion, the arrangements as they stand today are that communication between the Valuer General and Valuer General New South Wales needs to occur between and only between certain executive members, unless there's some ad hoc or circumstance that may require some other sort of forum to be convened. But essentially, how it works in practice is the Valuer General communicates with myself on a day-to-day or basis or as required, or with a colleague of mine, Sally Dale, who's another acting executive director in Valuer General New South Wales.
Okay, so under the existing arrangement, the Valuer General is entitled to communicate directly with 4 people, is it? 4 executives?
I need to take that on notice, but certainly he's as I said earlier, he can communicate between myself and Sally for matters that relate to Valuer General New South Wales, and he can obviously also communicate with my boss, Michael Wright, the Lead Deputy Secretary for Property in Place that oversees Valuer General New South Wales, as well as Mick, the Secretary for Department of Planning and Environment.
Can you give us your reasons, or at least your understanding as to why such an arrangement has been put in place?
My understanding is the arrangement was put in place as a result of complaints that occurred before my employment tenure with the department.
And what were the nature of those complaints, as you understand them?
As I understand them, the complaints were in relation to alleged or potential behavioural issues between staff and or the Valuer General during interactions.
So can we use the short term that there are allegations to do with that broadly fall within the umbrella of bullying and harassment?
Yeah, that's what I understand, yes.
Yeah. And do you have, of course we have to respect the privacy of the complainants and the nature of the complaints, but those complaints arose from the Just Acquisitions team in large part, is that correct?
I think I need to take that on notice to
okay, sure.
Answer that correctly. Yeah.
Are you in a position to tell us how many?
I'm not. I need to take that on notice.
Okay. And can you tell us when the last complaint was received?
That's something I'd need to take on notice.
Okay. And I've asked this similarly I think of a person who had your role prior to you having it in a separate parliamentary proceeding. But how long have you been in the position of Executive Director? How long have you been in this current position?
I started in the last week of November 2021.
Okay, well, congratulations. And have you yourself received complaints since you started?
I haven't received any complaints from staff that I'm aware of, but I'd need to take on notice to make sure that that is a correct answer.
Okay. And have you received any concerns or expressions of concern from any member of your team about certain interactions that might be had with the Valuer General?
No, not since I've been employed in the current role in November 2021. Okay. No.
But there were, as I understand it from evidence that was given by one of the former secretaries of DPIE at a budget estimates hearing last year, there was investigations, were there not, undertaken into some complaints that were received as late as September last year?
Yes, so there has been a WHS investigation, and I think I would probably need to say that I'm really keen, Mr. Mookie, to assist the committee and provide all the evidence that I can. this question probably is going towards matters that are under active consideration, as I understand it, from another committee. And I'm aware that the Joint Standing Committee has now written to the department asking for a briefing on these matters, and the department is in the process of facilitating that briefing. And as these matters are particularly sensitive for all involved, and airing them in a public forum raises questions of personal information protected by law, as well as those protections I went through earlier, I guess I would have to defer to those obligations that I've previously raised and need to take the matter on notice if pressed.
Okay, I think I appreciate that, but therefore I think you might need to take on notice the question about whether an investigation was completed. Are you okay to do that?
So the investigation has been completed. I'm happy to answer that, and as I understand it's the Joint Standing Committee has written to the department to seek a briefing on that investigation. That's in the process of being facilitated. I also understand that it's imminently being provided, if it hasn't already been provided, to the Minister.
Okay, it has been provided to the Minister?
If it hasn't, it is in the process of being provided, but I can certainly follow that up this morning.
Thank you, I'd appreciate that. Shortly I will pass to questions from my colleagues, but can I just say, in respect to the Just Acquisitions team, there's been at least 3 incidences that we've heard in which members of the valuation team have reached a certain conclusion about the value of a parcel of land. The Sydney Helicopters case study, are you familiar with that?
I'm not familiar in detail, no.
Okay, so in one instance we've heard that I would now probably describe as a more high-profile matter, that the valuations reached after failed efforts to jointly agree a value for a parcel of land for a company by the name of Sydney Helicopters, which operates a helicopter facility that assists in the SES and others. The valuation team reached a certain value, and then without notice to them, the Valuer General intervened and reduced it substantially and triggered a dispute. And to be fair to the Valuer General, he's made the point that he felt that that was A, within his power, and B, he thought he would apply the correct judgment and the valuation team was wrong. Do you have anything you can say about that? Or can you take on notice for a response from the department or your team?
So I can probably comment broadly. So how the valuation or valuations of those matters occur, but certainly in terms of the specifics of the matter you've mentioned, I would need to take on notice because I'm not familiar with it. But how valuations occur currently is that when a valuation is received on behalf of the Valuer General New South Wales, that valuation is quality assured to ensure it complies with standards, procedures, guidelines, relevant legislation. At such time that, at present, I'm comfortable that the relevant checks and balances have occurred. The matter is submitted to the Valuer General for either review and noting, if it is a preliminary report that's been issued to the parties for comment, or approval if it is a final determination. Now, when that is submitted, on occasion or routinely, there may be comments from the Valuer General, and those comments may lead to a change in value, or they may not lead to a change in value. But as I understand it, that is certainly the Valuer General's discretion and his relevant provisions or powers as a statutory officer facilitating the Act.
Well, that's helpful, Mr McLaughlin, but at least in this specific incidents and in others, the complainants about the Valuer General's conduct are not just the people who had lost their land in a compulsory acquisition, it's the actual members of the team that were valuing it. And which is sort of why it's quite startling for us as a committee to hear that within the valuation team itself, there's concerns about the Valuer General, for want of a better term, randomly intervening and reducing values. Now, have you heard such complaints yourself?
No, I haven't. So every matter that the Valuer General reviews since I've been in the role is that feedback has been provided to the team through myself, and the comments have been addressed or taken on board or explained in the appropriate manner.
How many valuations has the Just Acquisitions team completed in the last 12 months?
I need to take that figure on notice.
Yeah, I guess the valuations that I'm specifically referring to are the ones in which determinations is probably a better way of putting it, in which the property value has to be determined under the Act. Do you know that one?
So determinations, I guess, to pull it to a broad sense, any matter that is gazetted is a matter in terms of compulsory acquisition that needs to be determined. So I'm probably not following. So how
Sorry,
a matter comes to the value.
I guess the one I'm specifically looking for is that there's the valuations after the parties failed to reach an agreement. Do you have any idea as to how many numbers of that have been done in the last 12 months?
In the last 12, no, but certainly I can talk to during my time and certainly since the delegations have predominantly changed. So I did do a couple of figures if that's okay.
Yeah.
So certainly just analysing specifically a few periods. In the period 13 September to 3 December, so a 12-week period, the team were able to issue 47 reports, and that is either preliminary or final. I'm pleased to say that as a result of some further business improvements and realignment of resources as well as other factors in the period 6 December to 11 March, so the subsequent 12-week period, the team has been able to issue 129 reports, either preliminary or final. So in terms of output, we're at about triple the output at the moment to where we were in the former 12-week period.
That's because there was a bit of a backlog, wasn't there, Mr. McLaughlin?
I don't think the amount of matters the department is assessing or not assessing probably goes to the amount of output, because we probably had more matters when we were achieving the smaller output than we do when we're achieving the larger output.
But I think the Valuer General's reports, annual reports and others, show that there was a significant deterioration in the ability of the Valuer General's office to complete these determinations within the statutory time periods. And that's been established. In fact, we as a committee have heard multiple complaints, not just of the outcome evaluations, but actually the timeliness, which is causing more concern in many senses. And that is a whole bunch of people come to us and said, going to the Valuer General's office will take far longer than we were told, that we expected. We're hearing that from everywhere. Do you want to respond to that? We've heard that from residents in Orchard Hills. We've heard that from the Tigers Club, and the people who are developing their site. We've heard it from Sydney Helicopters and others. There's just almost every single person who's come before us to talk about their experiences have complained not just about the outcome, but actually about how slow it is to get an outcome from the Valuer General's office. Do you want to respond to that?
So I would say that there's always room for improvement. The numbers I previously referenced probably demonstrate that there has been significant improvement, particularly in the last 3 to 6 months. So our output is now at about three to four times the output it was, say, in August or September last year. So we are starting to, as a result of some structural and other business improvement initiatives we've put in place, as well as removing where possible duplicious administrative processes, we have improved. In terms of the days taken, the days taken are still outside the statutory timeframe, and that's something we're well aware of and something we're working towards to reducing, and we're working with the Valuer General to do that. So in terms of the process moving forward, which is something we have discussed with the acquiring authorities as well as the Centre for Property Acquisition, on 10 or 11 January this year, we implemented a new process called Just Terms 21. Under that process, there are relevant drop dates for both the claimant and the acquiring authority, or drop dead dates as we call them, where information needs to be provided. So in some of these matters, yes, it's less than ideal, the timeframe taken, but depending on the specific matter, and I need to investigate each and every one, but at a broad sense, there is generally a reason why it's taken that time, whether we're awaiting experts or consultant reports, whether we're awaiting details from the claimant, which does occur a lot, or whether we're awaiting details from the acquiring authorities.
But, Ms McLaughlin, aren't you not just ignoring the obvious elephant in the room here, which is part of the reasons why there's a delay, is because the Valuer General is only allowed to talk to 4 people arising from the way in which he himself has conducted himself? I mean, is it not the case that we should conclude that an arrangement which I describe as farcical is resulting in people who are having to lose their property to the government also having to suffer interminable delays? Is that fair?
I would say for any process or approval process, so this is not dissimilar to other approvals government does or doesn't issue, or determinations, where you add multiple layers of parties to review a matter, and in this instance, if you add another layer being the Value General on all matters, or in essence you have to communicate through certain channels, then that will increase the time taken to deliver the service. Yes, that's logical.
So it is the case that landowners who have lost their home are also losing their rights under law because of the turmoil that's engulfing the Value General's office. Is that fair for us to conclude?
I'm not sure whether I'd put in those senses that sense, but I guess how you wish to conclude a matter is up to you. I guess in my opinion, I just prefaced how I probably conclude that there are certain factors that will delay matters regardless of whether you're in the Value General's office or not. If you are.
My final question is, how many of the 129 and 47 reports, or for that matter, just beyond that, right? How many just terms acquisitions valuations settled by the Valuation General is currently before the Land and Environment Court, subject to appeal?
I'd need to take that on notice.
Mr. McLaughlin, can I just come back to that point about the limited communications channels with the Valuer General? What does that look like in practice in terms of the work that the department does and the need for that to be funneled through yourself or others? Can you just, I'm trying to get a sort of a real world example of how that might delay matters versus people being able to directly go to the Value General's office.
Sure. So I guess if we went through just at a micro level, an example, if you had a determination you were looking at presently, or my team was looking at, and again, these are, I think I would preface any answer that I've only been in the role since November, and obviously this is a process that I've been facilitating since November. Prior to that, or prior to the reduced communications, I'm unaware of the specific processes that used to occur, but certainly how I think it would occur. At present, a matter would be undertaken by either an internal valuer, although more likely an external contract valuer for the department. That matter would come to our team for review and quality assurance. When one of my senior managers or senior or principal valuers is comfortable that it meets the relevant standards and has done the relevant checks and balances, it would be sent to me. How that then is provided to the Valuer General is I undertake a final review to make sure that the relevant feedback the Valuer General has given myself or the team previously is ideally being implemented or considered in this matter, and if I'm comfortable that that's occurred, I send it to the Valuer General for review and noting if it's a preliminary, or review and approval if it's a final determination. In terms of the timeframes taken, I would say every matter that is being signed off, for want of a better word, from one of our principal valuers, the Valuer General would receive that within 1 to 2 business days of that sign-off, assuming I'm comfortable.
So that's the current process.
Yes.
How could it be improved, or how would it be made more efficient if there were more communication channels then with the Valuer General?
Well, the only layer you would probably skip is myself on matters where there are low risk or smaller determinations, because obviously the larger the value, the higher the risk in terms of potential valuation adjustments or other complexities in terms of expert reports may come into it, and certainly you would require further review. So it would probably reduce the time taken by 1 to 2 business days at least, if those other matters I talked through were going directly to the Valuer General.
Understood. Okay, so about 1 to 2 business days per low risk sort of matter, I guess. The understanding being that you would ordinarily, I guess, be looking at those more complex matters. Is that what you're saying?
Certainly, yeah, and I think, as I understand it, that did occur in the past. So obviously, within departments or within state government agencies, there's delegations, financial for procurement, but also for determination. So if you have matters that are, at present, there's some that are in the hundreds of millions of dollars. Those matters would not just be going from a principal valuer to the valuer general.
Mr. Graham?
Great, thank you. Mr. McLaughlin, I want to ask some questions about the operation of the Just Terms Compensation Act. One of the things the committee is looking at is the evidence we've received about how that could be improved. I'm interested mainly in your observations or your team's observations about how it's working in practice on some matters of fact. So there's obviously some policy questions that you might not want to comment on, but I'm more interested in what is factually going on at the moment. Can I just put some issues to you, and then I'm interested in your perspective about whether this is factually true. One of those things that the committee has received evidence about is Sydney Metro being involved in valuations where the valuation offer doesn't increase by a single dollar, as it's been put to us, despite the fact that the Sydney property market has been rising quite rapidly over the past 12 months. Have you got any observations about whether that's factually the case in the instances you're seeing?
I think I need to take that on notice specifically, and if you had specific matters, I can certainly respond in detail.
Yep.
I would say that the acquisitions or determinations under the Act are done at the date of gazettal, so it doesn't take into account the relevant rising market in my mind if the acquisition took 8 months to determine. Yeah.
Thank you for that. One of the issues that's been raised with the committee, again, this has tended to be about Sydney Metro, is that the relevant sales comparisons are often 10 to 15 kilometres away from the subject property. Is that something that you have seen in the cases you're dealing with?
I don't know if I could comment specifically at Sydney Metro, but certainly when we undertake valuations within, or my team undertakes the valuations or contract valuers, certainly there are cases where we're using sales that are at times quite a field from the relevant property being acquired. But as you can probably appreciate, if you're acquiring a property, particularly, and I'm thinking of one more in regional New South Wales at the moment, but the sales comparison may need to be 100 kilometres away because there is no other sale of that type that has occurred. So that's just the nature of the valuation.
Understood, but one would hope, Sydney Metro's acquisitions will tend to be more in the urban areas. You'd hope you would have to move less further afield. Have you seen instances of that in the city?
Not that I would consider it significantly outside of the realm of the area, no. So, but I can take on a specific matter if you have one at hand and look at the details.
Thank you. One of the concerns is that acquiring authorities will often issue letters 2 to 3 months into the 6-month process. So even though the 6-month process could potentially be long enough, this is really putting pressure then on the system. Is that observation, is that evidence that's been given to us in your experience? Does that tend to be factually correct?
I'm not sure with respect to what you're referring to, what letter or which part of the process. So could you be more specific?
Well, I think it's the letter of offer.
Okay, so that would be a matter for the acquiring authority to probably respond to.
I'm asking, I agree with that. I'm just asking, does that accord with what you're seeing, that this is often being issued 2 to 3 months into the process?
Look, so in terms of the Valuer General New South Wales role in the process, and this is broadly speaking because I'm not the acquiring authority in these matters, But certainly the acquiring authority undertakes negotiations and with the relevant claimant or party at the time. During that negotiation period, if they can't reach agreement, they issue a PAN, the proposed acquisition notice to the relevant party to say essentially that we are going to acquire your property via compulsory acquisition. At that time, under the Act, the acquiring authority is obligated to notify us as without having the Act in front of me, but essentially as soon as practical. And that's when our role starts. So what happens before that, or if an acquiring authority takes a while to issue a negotiation, I wouldn't be best placed to answer or respond to it.
Yeah, okay. So you're just not aware of how far into the process those PANs are being issued, is your evidence?
Yeah, so Valuer General New South Wales is advised, or under the Act, required to be advised once a PAN is issued. And generally understood. That advisement would take 10 days to come across, say.
One of the bits of evidence we've received is that in some cases, issues were only raised by the acquiring authority through their submissions to the Valuer General. That is, landowners are finding out for the first time about issues not in the 6-month process or not prior to that PAN being issued, but in subsequent submissions that are made to the Valuer General. Have you seen instances of that occurring?
I think that's probably best placed for the acquiring authority to answer, but I'm not aware of certainly specific instances. But what does occur when the Valuer General undertakes or when VGNSW facilitates a determination is the PAN is, we're notified of the PAN. We then seek to procure services to undertake the relevant determination. As part of that, we may identify issues that neither party has previously identified because we are undertaking a separate evaluation. Whether or not there are issues that an acquiring authority or a claimant has advised the Valuer General that they have failed to advise during negotiations is a matter for them to probably respond to.
I'll certainly be putting it to them, but this is really referring to the part of the process you are closer to. I'm interested in whether you factually observe this is occurring or is this not occurring in your experience?
From my understanding, I'm not aware of specific instances where this has occurred where something hasn't been raised with the claimant and then is raised by an acquiring authority. However, I would need to take it on notice. That'd be helpful. And I'm more trying to get to the facts of what you observe in your work or your team's work as you're dealing with these cases. So certainly I haven't observed that
that is helpful evidence for us.
Yeah.
One of the concerns that's been put to us is that former owners or tenants have not received a draft determination from the Valuer General or an explanation for the delay, even months, and one case has been put to us 72 days since the date of gazettal. Is that something you're seeing?
Sorry, there's probably a few questions in there with respect. So I guess I'll do my best to answer, and then if I've missed a part, feel free to pull me up. So I guess when we're undertaking a determination from the date of gazettal, certainly as I explained, there's a new process from 10 or 11 January this year where we've introduced drop-dead periods. A draft determination at the moment, certainly 70 days wouldn't be uncommon, and we're working to reduce that down to the 45 days. So I don't think that probably sounds what has occurred in this instance. If there are delays or inquiries, both the acquiring authority or the claimant can contact the Valuer General and are assigned relevant details to do that, and we can talk through what is occurring on the matter. So on a lot of matters, there are expert reports that need to be procured, and as I'm sure you can appreciate, the market is quite constrained in all things that relate to valuations at the moment, and the timeframes we've been given, or for instance, I'm aware of a matter recently, we've issued it to 12 valuation firms, and all 12 valuation firms that the Valuer General would usually utilise that have the relevant expertise to undertake the work we need have all declined to quote. So
Right.
there is an issue in terms of timeframes.
Yes, that's one of the real pressure points that you're pointing to right there in the
Yeah,
system. Yeah,
certainly.
And what is the benchmark time at the moment? What is the average delay as you're measuring those, as you're trying to get it down to the 45-day mark?
Look, I would need to take it on notice. I know the time frame has gone up. In my mind, I know that, but I don't know the specific day. But the reason the time frame has gone up is not because new matters are going up. We're actually getting through matters that are, some of them have gazetted in July last year. So we're working through, as I talked through before, the significant increase in output.
Yeah.
Whilst we're getting through a significant output, if that matter has taken 200 days, the overall numerical number will go up, but once we clear that, the numerical number should go down. Yes.
Mr McLaughlin, you've provided really useful context about why this is the case, but this is a key benchmark, the 45 days. I am going to press you. You must have some sense of what is the average at the moment with all the context you've just provided.
I would need to take it on notice to get the specific days, but I would say it's around 120, give or take. But I wouldn't know without taking it on notice to give you the specific.
Yeah, but that's useful. So about 120 days. You're aiming to get it to 45. You've obviously lifted the work rates significantly, but that's still quite a big gap at the moment. You'd agree with that?
Yes, it's a large gap, but as I said, I'd need to preface that as we lift these work rates and we lift the output from VGNSW, which we are striving to continue to achieve, that number will have to go up before it comes back down because we're getting through matters that are significantly, long in their nature. Yeah.
And how much higher could that number go?
I'd need to take that on notice.
Yeah. In the meantime, while those owners and businesses are waiting, you'd agree they're continuing to pay loans. They're often paying rent to the acquiring authority. Often, shortly, they'll have no premises to operate out of. That provides other business pressures. These are all very real pressures as people wait that 120 days or more. You agree with that?
Sure, yes, I do. I would say, and probably a matter for the acquiring authorities, but I am aware that there are avenues whilst they await determinations in terms of prepayments from the acquiring authorities.
But you also accept that as each day goes by, certainly in the last year, property has become more expensive. So in terms of the ability of a person to purchase an alternative property, their actual spending power is going down at the same time they're incurring all these additional costs. Is that fair?
That's reasonable, yes.
Thanks.
And you referred to those payments, and again, this I want to acknowledge up front, this is more an issue for the acquiring authority, but I am interested in your observation about whether the evidence we've received is factually accurate. The acquiring authority does not need to pay former owners and businesses any money until 28 days after receiving all the necessary paperwork. Some of that paperwork will take a couple of months for the bank to approve. And these are all adding to delays for when owners actually receive money. So it could be former owners of businesses are taking up to 5 to 6 months after gazettal before they're actually receiving money from the acquiring authority. Does that evidence we've received accord with what you see in the system at the moment?
I think that's going well outside my knowledge of what the acquiring authorities can or can't facilitate, so I wouldn't want to answer.
Yep, no, I appreciate that. All right, thank you for that evidence.
Mr. McLaughlin, can I ask, is your understanding that the Act's purpose is to facilitate a joint agreement between the acquiring authority and the landowner? That's correct? That's the first preference of the Act? Is that the two parties reach agreement?
Certainly, yes. The desired preference is always an agreement between the two parties, and that's in any matter of, negotiations in my mind.
And you agree that people come to the Valuer General's office for the determination, or at least, predominantly, or a final determination in the event that they can't reach an agreement?
Yes, I agree.
And you agree that to the extent to which your processes in the Valuer General's office is seen as fair and timely impacts on how a party will conduct themselves in the first round of negotiations?
Sorry, you might need to put that to me again.
So, do you accept that a person's behaviour, be it that of the acquiring authority or the landowner, is affected by how they perceive they will go if they were to go through a Valuer General process?
I'm not sure I could put myself in the mind of a person or the acquiring authority and how they...
It's a reasonably
behave,
common
sorry.
sense proposition, though, isn't it, Mr. McLaughlin? I wouldn't see that as contentious.
You don't think that's not contentious, is it? That a person...
I'm not saying it's contentious, but I don't think I can go to whether a person would or wouldn't behave differently. In my opinion, if there is a process there, and I was in either parties, I would follow the relevant processes.
Sure, but some of the evidence that we're hearing is that certainly there is a perception amongst landowners that they will fare poorly in a Valuer General process, and that therefore they are more inclined to accept a reduced value offer from an acquiring authority because fundamentally they're far more fearful of you or your office having to decide the value of their land. We've heard that multiple instances. Are you aware of that concern?
I'm not aware of that, but certainly I couldn't talk to whether people are fearful or not. The role that we play is to essentially issue a final determination. So the only avenue post a Valuer General determination is to take the matter or proceedings to court to challenge that determination. And certainly any determination we issue takes into account the relevant policies, procedures, and requirements of the Act. So I'm not sure.
Equally, complaints have been raised about, and look, I accept this is complaints about acquiring authorities, but complaints have been raised about the conduct of, or about whether or not an acquiring agency is in fact negotiating in good faith, because there's a view that they're not, because acquiring agencies think that they'll always prevail in a Valuer General process. Do you have any insight into that, or do you want to respond to that concern?
I think that's a matter for the acquiring authorities with respect.
And equally, there's equally a view that's come through loud and clear that there's a resource asymmetry between a landowner and the acquiring authority, and that's, of course, one of the concerns is that the acquiring agency then conducts themselves in a way in which they don't negotiate in good faith in order to exhaust the resources of their counterparty. Is that a concern you've heard?
I haven't heard that concern, but again, we're not really involved in that front end part of the process, so it's probably unlikely something I would hear in any event.
But the concern then continues on in that only a few people have the level of resources required to bring a challenge to a Valuer General's determination in the Land and Environment Court. And in fact, given that there's an expensive process, there is a real concern that the system is just stacked in favour of the acquiring agencies, not in favour of the landholder, or at least even in a position to promote the two as being, or put the two at least on an equal bargaining framework. Have you heard that concern?
No, but again, that's not really a matter that the VG and SW looks after, so we're there to provide the relevant determination whether or not someone has the resources to challenge that determination is not really a matter that would be discussed with us in any event.
But you can accept, therefore, that given that the Valuer General itself, your average is 120 as opposed to the 45 it's meant to be, do you understand that just that delay is equally contributing to landholders feeling like A, the system is stacked against them, but B, that their resources are being exhausted, especially as your office, or the Valuer General's office, is now 3 times over, or close to 3 times over what they should be doing by law. Do you understand that that is one of the factors that might be contributing to that perception?
It may be, if that's the evidence you've heard. It's not something that I'm
but you agree
or
that,
have heard, but
But you agree that the reason... Sorry,
Mr.
You go. Sorry, you go.
As I've said earlier, though, certainly it is around the 120 days. We're striving to reduce that to the 45 days, and as the evidence I've already given, the output from our team and the relevant contingent and contract workforce has significantly improved to the order of 3 to 4 times that of what it was, say, 6 months ago.
Unfortunately, that's all we have time for. Thank you so much for attending this morning, Mr. McLaughlin, and answering those questions for us. To the extent that you took questions on notice, there's 21 days to respond, but the committee secretariat will be in touch to make arrangements about those. We're going to take a 15-minute break, and we'll be back at 11 a.m. Thank you.
Very good.
Thank you.
I'm back. So we'll now introduce our next two witnesses. If I could get each of you to please state your name and position title and then swear either the oath or the affirmation.
Belinda Sack, Special Counsel at Beattie Hughes and Associates. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Ms Sack. Mr Newhouse.
David Newhouse, partner, Newhouse and Arnold Solicitors. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Excellent. And would either of you like to make a short opening statement?
We both would?
Yeah? You go first, Ms Sack.
Okay. This submission is made on behalf of Beattie Hughes and Associates. It's based on our experience acting for dispossessed owners and resuming authorities for over 25 years, primarily in New South Wales, but also in Queensland, South Australia and Victoria. For many homeowners and businesses, the compulsory acquisition of their land is a devastating and alien ordeal. Government has a responsibility to conduct this process fairly, transparently, respectfully, and in a manner which does not lead to arbitrary outcomes. We have identified three key problems with the compulsory acquisition process. Firstly, at the point they are served with an opening letter or offer of compensation, owners are put at an enormous information and financial disadvantage. Secondly, the resuming authority, who is frequently the agency responsible for constructing the project and paying for it, has little incentive to make a genuine effort to reach agreement with owners. And thirdly, there are inadequate statutory protections for owners if the land to be acquired changes or the acquisition is ultimately abandoned. Rules for calculating compensable losses are arcane and often do not match how land or business owners value their interests in land. The resuming authority's offer letter bundles compensation into a lump sum that is not supported by information identifying how that amount was reached. Owners are then required to incur expense upfront in engaging experts to assist them understand the process and their legal entitlements. This is unfair. Over the last few years, the compulsory acquisition of land has devolved into an adversarial contest in which the resuming authority presides as judge, jury, and executioner. This leaves little scope for dispossessed owners to participate meaningfully in a process which is likely to have life-changing consequences. In our view, a resuming authority ought not be wedded to its own valuation and fail to or refuse to consider the dispossessed owner's valuation. Instead, the resuming authority's valuation ought be the starting point of the negotiation, not its predetermined end point. The resuming authority ought not conduct negotiations in a perfunctory manner and dictate the terms and conduct of any discussions, including not letting owners speak or refusing to allow experienced experts to meet unsupervised. The resuming authority ought not dismiss the views of experienced valuers out of hand if they're acting for dispossessed owners, noting that often the same valuers are used by a government in other matters. The resuming authority ought not ignore its duty to resolve doubts in favour of the dispossessed owner. And in instances where there are contiguous parcels of land or large strata acquisitions, it ought not pick the owners off one by one or directly contact the owner when they know that they are legally represented. In our written submissions, we have suggested measures to better ensure that resuming authorities make a genuine attempt to acquire land on just terms by agreement. Our four recommendations are, firstly, to provide access to funds up front so that owners can obtain expert advice, and second, and also that to require the resuming authority to provide its valuation report with its offer. Our second recommendation is that there ought to be an opportunity for alternative dispute resolution early before a PAN can be issued. For example, allowing for peer review of expert reports or conducting negotiations in the presence of an independent mediator. Thirdly, owners ought to be reimbursed for incurred cost in circumstances where a compulsory acquisition process is commenced but the acquisition is ultimately abandoned. And fourthly, that the negotiation period ought be extended in circumstances where the area or location of land to be acquired has changed materially during the negotiation phase. And a final comment is to address the arbitrary nature of the application of the Just Terms Act. Consideration should also be given to reviewing the Act as it relates to stamp duty on a replacement property, as this has led to arbitrary and the current approach has led to arbitrary and unfair outcomes. Thank you.
Thank you. Mr Newhouse.
Madam Chair, Deputy Chair and committee members, I've been practising the land acquisition space for over 20 years and have acted for the New South Wales Government as a barrister at the beginning of my career and for members of the public as a solicitor for the last 14 years. I've seen both sides of the fence, and the process for land acquisitions has never been so problematic. The evidence and submissions that you have heard are only a tip of the iceberg. We've seen a consistent policy of stonewalling by acquiring authorities in recent times. Some authorities are clearly not making genuine attempts to acquire land by negotiation, which means that more and more matters will and are going to the Valuer General, or owners are worn down by the process to just accept the low offers. All committee members should be concerned about the acquiring authorities taking advantage of the elderly, those from cultural and linguistical diverse backgrounds, minority groups and the disabled, and those who just don't know how to get help. These are just some of the people you have not heard from throughout this inquiry. I have many stories, but there is one that I will never forget. A single mother with a disabled daughter who said the process has worn me out and it's just easy to accept the low offer. That young mother, her disabled daughter, had to move out of a supportive community and rebuild their lives with less resources in a different part of Sydney. All because this process has allowed acquiring authorities to take advantage of these families. I have countless stories of owners who are in the same position. Some we could help, but others were worn out by the process and just accepted the low offers. For these families, it's more than just money. They have a history in their home, a loved one's ashes spread across the garden, a horse or dog buried in the backyard, children's height charts on walls. I was told late last year that a child died in the lounge room. These are real people with real stories who are impacted by the government's proposed project, and the Act ignores these stories, and the acquiring authorities treat them like a statistic, often with no empathy. With the amounts that are being offered, they cannot buy back in the same market, and their assets are being diminished with the delays in getting a final answer, whether it be from the VG, which you're aware takes 3 to 6 months, or through the court process, which can take 1 to 3 years, putting these families even further behind financially and emotionally. Even earlier this week, I watched a hard-working family in the Hunter Connection who works from 5 a.m. to 5 p.m. at night every day, met with Sydney Metro, who essentially demanded they just accept their valuation with a take-it-or-leave-it attitude. The process is seriously unjust. With the acquiring authorities when they choose not to genuinely participate, there's nothing more we can do when this happens but to allow the Valuer General to make his decision, which is now costing the taxpayers even more money. As I understand, the acquiring authority must pay the Valuer General around $20,000 each time a matter goes to him. Just remember that these families didn't ask to sell their properties or force these businesses to move. They have been living or working there for years, and in some instances decades, and it's the government forcing them to leave under the government's terms, which supports a one-sided process which will wear these families down to accept a lower amount of money. One last example of the one-sided approach was Sydney Metro's acquisitions for the Westmead station. At the time of the announcement, there were numerous sales in the same street ranging between $550,000 and $580,000 for a typical 2-bedroom unit. These units in the street were all originally built by the same 2 developers. They were all very similar in nature, but Sydney Metro's original offers were typically 10% below these sales in the street. It took 9 months, countless meetings to resolve these matters before common sense prevailed. When in the very last week of the acquisition process, around a dozen of my clients resolved their claims with sales within that range in the street. They had to wait 9 months to receive fair market value. Why couldn't Sydney Metro offer that amount in the first place? It would have eased the pain that these families went through and allowed them to buy back in the same market. At the same time, there were countless letters to politicians and ministers who merely referred them back to the department for answers. By the time they received their money, the market had gone up nearly 10%, forcing them to repurchase in other areas in Sydney. I've set out some of the key reforms in my submission. However, since my submission, I've tried to work out if there could be a better system. The problem clearly arises because every agency, whether it be RMS or Transport for New South Wales, Sydney Metro, local councils and other government departments have all different internal procedures. There appears not to be any consistent approach across any government department. We have matters on the South Coast which have been going on for nearly 3 years. These road widening projects have now been completed, yet the council refuses to issue a PAN and compulsory acquire the property. We have had matters with the Western Suburbs Council where the opening letters were issued in May 2018. The properties were gazetted in October 2021, 3.5-year process. Normally there would be a 9-month process. Final determinations, the Valuer General came back a few days ago, nearly 4 years later when they were first notified. The council in those matters did not increase their initial offers, despite the market moving upwards in the 3.5 years, and there was ample sales evidence of increases. We have had similar approaches where not a single dollar more was offered by Sydney Metro and Burwood, and the CBD Metro Station project is beginning to take a similar vein. We've been told that there is a new Metro internal policy not to deviate from the valuation reports unless there's new evidence provided. You cannot have genuine negotiation under these terms. We have another matter against the council in North West Sydney, who have provided offers of compensation for a strip of land to build a new roundabout. We have provided our reports to council only to be told that the project is stopped, and then 2 days later, the same council now wants to negotiate purchasing the whole of our client's property for the project, but not under the Act. From our experience, we are generally achieving a higher success rate to those agencies like Transport for New South Wales, who have dedicated employed acquisition staff to deal with the acquisitions daily, as opposed to the Sydney Metro contractor model or councils who have property officers who deal with 1 or 2 acquisitions a year. The solution here is for all New South Wales acquisitions to be assisted or determined by the Centre of Property Acquisitions, who should utilise employed and experienced acquisitions officers like the Transport for New South Wales model. This could alleviate the different internal approaches and procedures so one agency determines all acquisitions in New South Wales.
Thank you very much. If I could just pick you up on that last bit before I hand over to my colleagues, I think that's a really interesting idea, and I was about to ask you sort of, which of the agencies do it better in your view, but as you've said, it's the ones with the better experience, I guess. But what makes the Transport for New South Wales team better? Is it because they have a dedicated team, or is it also a kind of cultural and is there anything in the manner of their approach that's also different?
I think there's 2 issues. One is, from my part, if I can interject, there's 2 issues. One is they're using employed staff who are there seeing this on a day-to-day basis. Okay. They typically have valuation experience, and the most important
Apologies, could you move the microphone just slightly closer to you?
Do I need to repeat that?
No, that's fine. Thank you.
So they use employed staff, typically with valuation experience. Mm-hmm. They're there on a day-to-day basis. And most importantly, there's a process in Transport for New South Wales that if you do have a grievance, you can, until recently, escalate it up the chain. So, until recently. So the new director unfortunately refers matters back to the same officer, but until previous matters, we always had the ability to go to people like Bernie Mills and Arunda Prasad and those people, and at least have a sensible discussion with them, with valuation evidence, and they would then get peer reviews and they would look at the process and come back to you. We would not always agree, but at least there was a process. With Sydney Metro and others, there's no process. You can't go up to senior management and have those discussions. So you're left with the contractors at the ground level, and you can't have those negotiations. You can't have those sensible arguments. You can't present that information to show them the differences.
If you had a separate agency that was doing all of this for all of the acquiring authorities, would that, also take away the sort of maybe the inherent what am I trying to say here? So if an acquiring authority is doing this process themselves, they obviously have a very strong interest in trying to get the lowest price possible, which is perhaps part of the problem, and perhaps is leading to the stonewalling and the game playing, because they know that they can go to the value general at the end. But if every acquisition was actually undertaken by a separate agency, is it your view that that would also sort of remove that sort of approach or incentive to perhaps be to give low offers and be a bit tougher?
You'd hope that they would provide independent market valuations, which is what all we're trying to achieve.
I mean, I think actually then another point is this sense that you're dealing with a resuming authority that has skin in the game and wants to get the price down as low as possible. There is no sense when you're going into a negotiation that it is like a mediation, a meeting of equal parties, or there's an independence to it. There's just, you have this stone wall of, it's my way or the highway, walk out. And that is extremely distressing for owners, because they have this false, I suppose in a way, a false hope of a process that is fair and they will get just compensation, and yet the first time they see the resuming authority face to face, it's very clear that this is not a negotiation. I mean, I've even been in negotiations where the first words coming out of the resuming authority's mouth is, "This is not a negotiation," and you're just like, "Well, hello, why are we here?" I mean, so that it's. I think an independent voice early in the process is important, whether it's by way of a dedicated agency or we've suggested having an opportunity for a mediator, but it's that's lacking at the moment, and that drives the outcomes.
So the Act is set up to, I guess, it's based on the assumption that we have fairly equal parties coming together to make it, to negotiate and make this agreement, whereas in practice we have a huge power imbalance. And your recommendations, Ms. Sack, are around, I take it, to sort of try and rebalance that power and to make it more of a fair negotiation. Is that correct?
Just to make the negotiation more fair, so that you can, as an owner, come in with experts, but also have a sense that the process is independent, that there are, and that seems to be what's lacking at the moment, this sense of an independent voice through the process.
One final question, then I will hand over to the opposition. Do you think that there is a case to be made that we should really have a different type of process when we are dealing with homeowners and small business owners versus property investors and large businesses? Do you think there should be sort of
I mean, our experience is largely with businesses or larger corporates. David's sort of the other, more on the other side. So we're coming at it from slightly, I suppose, different experiences. I do think there is a difference. I think there's a difference between the approaches. I suppose David might have a.
I think the difference is from the smaller mums and dads and the smaller businesses, they are more readily going to accept the low offer because they can't afford to go to court. Where the larger businesses have the money to go to court, and there's more at stake.
the emotional aspect as well, I guess. We've heard from a lot of people who have had their homes acquired or about to be acquired, or and they spoke a lot about the distress that causes when you're having to move home to a completely different place. It's the uncertainty, it's the costs, it's everything else. It's not having the immediate resources to know what you're supposed to do in the process. Clearly, that is a very different situation to someone who is sitting in a big corporation and they've maybe invested some property that has no home on it, and it's completely there's no emotional connection for that person. Should there be a different process for dealing with those?
I suppose one thing that's important is, even though they may be larger businesses or corporates, one shouldn't underestimate the amount of, I suppose, energy, effort and emotional commitment that those businesses have made. I mean, especially in the Sydney area where land is so tightly held and such a premium, these businesses have been on these sites for a long time and are making the most of every single bit of that site. And unravelling that when an acquisition comes through is something where, and that it sucks resources out of the business for years trying to manage and go through the process of compulsory acquisition. That they never get back. There is no mechanism for compensation for the fact that you'll have to have 2 dedicated staff in your business that are basically spending all their time managing the acquisition process. So there are differences. There are significant impacts. It may be, I suppose, in a way less emotional, but the impacts are still significant. I suppose, one of the things that the sums of money are larger. So I think the egregiousness that David talks about, you just see that the mean-spiritedness is a real issue at the residential owners level. But we've got a lot of clients that are heavily invested and committed in their locations and things that they need to be in that location because that allows their business to operate, and all of a sudden you suck them out of that location and the business can collapse because they don't have that network for their market.
Just very quickly, I know you want to move on. The solatium or solatium, section 60, that only goes to residences who live in, owners who live in those properties. I don't understand why that doesn't go to anybody. It's supposed to be for the inconvenience that's caused. It's a nominal statutory amount. It's gone up. I'm not going to quiver with the amount. That's a matter for government. But that should go to everybody who gets a knock on the door by 2 acquisition officers.
Thank you.
Thank you, Chair. Firstly, thanks for your submissions. They've both been really helpful because they talk about some real solutions to the issues. We've had quite good evidence about what the problems are, but I think both of your submissions really go to some of the potential answers and in real detail. So firstly, thank you for that. I do want to just touch on some of the problem briefly first, though. These are important powers. They've been used more given some of the big projects that are underway in Sydney. There have been improvements, though, to how some of this works. That's been part of the case. It's been put to us in the government submissions. I'm interested in your view, though. Has the process of compulsory acquisition improved at all, or do we still have a major problem?
If I could say, we have a major problem when you've got internal policies saying they're not going to deviate from the evaluation reports, because valuation is an art, it's not a science, it's not black and white.
And Ms. Sec?
That's, sorry.
That's useful.
I've had the same experience. I feel like at the moment it's actually worse than it was several years ago. And look, it may be the fact that there are larger projects and there's more happening, but it's definitely, it feels worse than it was.
Thank you for that perspective. And looking at the some of the specifics here, a range of properties being acquired by a range of different agencies, but you've highlighted the difference between, say, for example, the former RMS, which was doing a lot of acquiring, and what's going on with Metro. We have had evidence that it's really, there is a cultural issue on the Metro side. That's where some more of the evidence seems to be coming from. Is that a fair observation as you look across the system? Firstly, Mr. Newhouse.
My concerns are you've got contractors running the Metro project. So where I'm seeing the problems is not just the Metro project. You look at local councils as well. When there are people that are not invested in it on a day-to-day basis, whether they be contractors or acquisition officers, property officers who do 1 or 2 a year, you're not getting the same consistencies as as Transport for New South Wales.
Great. Okay, thank you, Ms. Sang.
And I would echo that the difference in approach does come from, I suppose I use kind of contract mercenaries, but that's the feel that you get in the approach, and certainly the matters that we have had with councils, you see that they just don't deal with this regularly, and it's challenging for them as well as being challenging for the owners.
Thank you. One final question on the problems. one of the issues potentially is that the Sydney Metro team is issuing a valuation range rather than a valuation offer. Do either of you have any observations about whether this is occurring?
Well, I mean, I think the important thing is, I mean, valuation is sort of part art, part science. There's not a clear number. What a valuer is required to put themselves in the shoes of a hypothetical purchaser and postulate an amount that that hypothetical purchaser would pay at an arbitrary nominated date for the property. So experienced valuers always provide a range, and it's always actually an indication of whether you've got a good valuer or not, is if they provide a range, then they know what they're doing because they know it falls within the range. The court accepts that it falls within the range. I mean, that's part of the reason why there's a very clear, right from the High Court, saying that if there is doubt and it falls within a range and the range is reasonable, then those doubts ought to be resolved in favour of the dispossessed owner. So one ought to go to a higher side of the range rather than lowballing.
Yep, Mr Newhouse.
And what we're seeing exactly on that issue is we're seeing agencies like Sydney Metro having a range but picking for some reason the lower end of that range, which is causing a lot of frustration with my clients and other owners and businesses where they're seeing a range and they're saying, but how come they're giving us the lower end?
Just turning to the solutions, just rapidly to touch on some of those, because you've set out quite a lot. Mr Newhouse, in your submission, you've said you believe the 6-month period is sufficient if the acquiring authority is making genuine attempts.
Yes.
Ms Sack, do you agree with that evidence?
I mean, I
it
think
could be sufficient if
it would
there's
be
a
sufficient
genuine
if there were genuine attempts. It has been sufficient in the past, but now it feels like there's not the genuine attempt. And it is important. I mean, speed is important because you want to be able to buy back into the same market and not.
You've both said having access to funds up front would be important, or that a portion should be paid. That seems like a common sense solution. Do either of you want to speak to that matter?
Just very quickly, in the sense of when the Gazette Day, if you don't reach agreement and it's, your property's gazetted, you've still got to keep paying your mortgage. You've still got, and then the acquiring authorities start charging you rent on top of your mortgages. So if you have access to those funds, at least they can go to the banks and stop that bleed. They do get interest, but it's at about 2% at the moment. So it's very minor.
Yeah, no, I think it's important to get the money up front. I mean, it is costly, and you, as an owner, you're served with this document that has this number that makes no sense. I mean, I think it's important as well that you get the resuming authority's valuation report as well, so that you have some confidence that there's a reason for the number.
You both agreed on that, yeah.
And then that you're going to have to engage experts to help you, and that's an out-of-pocket, upfront expense.
Well, let me just put to you the view that others would put, though, which is, look, of course you'd say that that money should be there for advice, because often you're providing the advice and you're paid for that advice. I mean, how much of a difference does it make to be able to pay for that advice? What happens if that money isn't there and someone can't afford to pay for that?
Well, I think if the money, if you're thinking about a small business, for example, and there's a lease as well, so there's a number of different interests. They are looking at a $10,000 plus out of pocket straight away. They've just had a knock on the door and said they're losing their land, and all of a sudden, and they're required to fork out money to understand what's going on in the process. It just seems entirely unfair.
And Mr Newhouse, what are you saying?
Look, my view is if you don't offer that, people will just accept the low offers and just move on because they won't know what to do.
And in some ways that's more likely with residential people, with people who've got less power.
That's correct.
Yeah. I might stop there and turn to my colleague.
Firstly, again, to both witnesses, thank you so much for the submissions that you have put together. They were both excellent. But Mr Newhouse, I wanted to ask you about some of the case studies you made reference to in your submission, if you don't mind.
Sure.
At the time that you wrote this, which was May last year, you said that you were aware of Sydney Metro having had more than 70 property and business claims referred to the Valuer General as an agreement could not be reached. And that excerpts on page 2 of your submission.
That's correct.
That's an incredibly high number, isn't it?
It is a very large number, and I had about a dozen, which is the most I've ever had in
And where were
all
they
my
come
years of practice.
And were they coming from a particular line that Sydney Metro was building, or
They came from 3 areas: Five Dock, Clyde, and from what I understand, Five Dock, Clyde, and Burwood.
and this was really for the construction of the Western Metro, which is the Westmead to the city connection. That's correct.
That's correct.
Yeah, and you tell us about this in the submission, and you tell us about what was going on in Burwood, Concord, Clyde, and Five Dock. Do you want to take us through that? What happened?
From my side of things, what I was seeing, there was Sydney Metro had drew a line in the sand, and were not willing to give $1 more on their valuations. The Valuer General did come in and assess independently market valuations, and all of my clients that went to the Valuer General came up significantly, sometimes double.
Double.
There were.
And that's after the Value General process.
That's through the Valuer General process.
And
So when you're advising your client and they have the time and ability, because most of these were small businesses,
yeah.
and they had the time and ability, they allowed that process to go through to the Valuer General and have an independent umpire have a look at it.
So, did you ever seek after the Value General determination, did Sydney Metro ever provide you or your clients with an explanation as to how they got it so wrong?
No.
And how many of those matters are still currently subject to dispute?
There are 3 matters that of mine that are in the court process.
So they've gone to court.
Yes.
Okay. And is there any other instances since the submission around Sydney Metro that affects that part of the line that you think that we should know about?
No, but I am aware that a number of matters still went to court, particularly in the Five Dock area. They're not mine matters.
Yeah. Fair enough. Can you then take us through the point you're making as well around how Sydney Metro engaged lawyers and town planners to identify technicalities?
So the process says what a hypothetical purchaser does. So when you and I go to a property, we don't go and get town planners and lawyers and looking at all these ins and outs of nuances to try to get the valuation down.
Yeah.
What we do is we look at it. Sometimes you might have somebody do some calculations on the back of an envelope. We might look at some leases, but that's generally what we do, and that's what a hypothetical purchaser does. The process has gone completely skewed towards relying heavily on experts, planners to say what's going on. I think you saw it in Orchid Hills as well. That suddenly we're so reliant on these experts, where that's not what a hypothetical purchaser should be doing. So the agencies are now engaging more and more experts to try to assist their case or their
I think
position.
actually the other thing in terms of technicalities is that a lot of very fine distinctions are being made, and it's a fairly typical occurrence that you will have a single director company that operates the business or owns the land, and in those circumstances there are these fine distinctions being drawn which says that in this circumstance you don't get stamp duty, but the place next door, which is almost identical, they get stamp duty because they have arranged their legal affairs and in a slightly different way, even though it's all the same sort of interest. So I think it's this kind of nitpickiness around the way it's being approached, and we appreciate some of that's being driven by the courts, but it's certainly the acquiring authorities are leaping onto that with great enthusiasm.
Look, but when you say the acquiring authorities, is that more than Sydney Metro who are doing it?
The majority of our matters are currently with Sydney Metro, so I suppose that's the experience that we're having. Obviously, we've had that a little bit from RMS previously, but I think it's just more that's where the majority of our matters are coming from at the moment. So that's what we're seeing and what we're responding to.
Fair enough.
I think the issue of stamp duty is I think a really egregious one, and I'm constantly having to explain to owners and say, well, no, sorry, I know that it's unfair, but you will not get stamp duty, you will not get cost of the replacement property, but hey, if you had a broom cupboard in that place as landlord, we're off and running and you'll get your stamp duty, but no broom cupboard, you get nothing. So it's that type of issue.
So can you just explain to us what that legal distinction is and how that is worked out, if that's possible?
Well, the issue is that you get stamp duty if you have an active use of the land, is the way the legislation has been, I suppose, is drafted, but it's also the way it's been interpreted. So you need to have an active use of the land. So the courts have then drawn this distinction between a passive investor. So if I own and rent, if I'm a landlord, then I'm a passive investor. I have no active use, therefore I'm not entitled to stamp duty or costs of the replacement property. So what that means is for my clients the smaller clients where they previously operated a business out of that property, but they are now leasing it out. They have valuable CGT benefits. They want to and they will buy a replacement property because that's what they'll do, but they get no stamp duty. They get no cost of the replacement property. So it's that kind of distinction. It then becomes where you have people are relying on properties for their superannuation and everything, but they're all of a sudden they're 50 grand out of pocket if they buy a replacement property, which is unjust.
So I take it when you say about the broom closet example there, if they retained a broom closet on the site that they used themselves, then they would be able to qualify for that stamp duty. That's correct? Yep.
Yeah.
Okay, thank you. Sorry.
And my solution there is just a credit, not to actually give. The government should not be handing out the money unless you repurchase another property. And my view is for the same period of time when you've got to elect to pay capital gains tax, which is 1 to 2 years, you should, if you buy a property in that time, you should get a credit on the stamp duty. If you don't get any money. Yeah. So it only benefits those people who rebuy a property. Yeah. It's not a handout.
Because I think
making good effectively.
Yeah, I mean so we act in other jurisdictions. So the situation, for example, in Victoria, we recently reached agreement on one matter where, and the arrangement there is that you get a stamp duty rebate, but it's reimbursed if you buy within 12 months, and the value of the rebate is an equivalent property. So that's the way that arrangement works, which seems perfectly, because there will be instances, for example, that an owner will get stamp duty. A business owner would get stamp duty and cost on the replacement property. They get that money up front, but then they decide not to buy a replacement property and instead to lease somewhere else. So they've had a windfall, and yet you've got other people that don't get anything.
And you take us through another example in which Metro draws distinctions between people who have long-term leases on paper and those who are operating on month-to-month leases just by having long-term histories of occupancy. That seems overly arbitrary and incredibly mean-spirited, that a person who's been in a place for 10, 15 years can be thrown out just because their lease happens to be a continuing lease. Am I wrong?
Yeah, I mean, it is mean-spirited, but it is something that it has. This has come from the courts where they've said it's about the security of the tenure. So there are instances, for example, if you have a business, you're the owner, you have a single director company that runs the business, but you don't have a formal lease arrangement in place because you're effectively leasing to yourself. In that circumstance, the business is kind of cut adrift because they have no security of tenure because they're on a month-to-month handshake arrangement with effectively themselves.
And Mr. Newhouse, you then go on to talk about those who do then seek access to the value general processes and the massive delays that they're experiencing in getting a result. Can you take us through that?
I think that was unique to those 70 matters hitting the Valuer General. To be fair, though, the Valuer General, we understood, was having meetings. They did stop when we raised this issue. They were having meetings with the acquiring authorities like Sydney Metro every week to know what was coming through into what was going to be referred to the Valuer General. When we raised that, said, can we attend those meetings? They did stop, which was good. But there was we understand that you had 70 matters come along and they just didn't have the resources we expect to deal with so many matters. And you've got to also remember that the Valuer General is receiving generally the more complicated matters. So the easier ones generally won't go to the Valuer General. I've got one still at the Valuer General that's very complicated out at Kemps Creek at the moment. And it has well exceeded the time frame. But they are complicated matters.
And then you made reference to this before about some of what's going on with Hunter Connection. Are you representing people who are in the Hunter Connection?
Yes, I am.
Ms. Sack, are you as well?
Yes.
How's that going? Can you give us an update from your perspective? Because this one, as you rightly pointed out, was notified last year, but it's live now, and it's.
Well, I mean, obviously, I mean, we're in a, I suppose, without prejudice
Yes.
negotiation phase, so we need to obviously be very careful about anything that we say. But it's a process that our clients have found very difficult. We're part through a process. There are, I mean, some complexities around it because of the nature of, for us, we have the nature of the business interests. But, I mean, these are the, I suppose, negotiations that we feel aren't really negotiations. They're the sort of, here's what we're prepared to offer, walk away. And, I mean, the problem with that approach also is that it just encourages people to sit it out and wait for the VG, which then adds to the backlog on the VG. I mean, at the moment we're having... If you're in a situation where when the Valuer General looks at it, they're offering, I mean, in our case, I mean, we've got very large interests, so percentages make a difference. But when we're looking at 15 to 20% uplift when the Valuer General looks at it, you've got to say there's something wrong with the process. I mean, David they've got larger uplifts but smaller quantums, but it just indicates that there's something broken early on if you're consistently getting significantly larger amounts from the Valuer General. The problem is you've just got to wait for so long to do that.
Yes.
From my side of things, I did some very successful work with Sydney Metro and St Mary's. And the reason we did success there was because we had our QS reports, quantity surveyor reports, we had our differences, and they're usually around the contingencies and the mathematics behind those reports. Sydney Metro agreed to get them peer reviewed. That process was excellent because we walked out of those and I got 12 out of 12 after that peer review. We used the same experts, brought those St Mary's into the Hunter Connection and all those areas, and we're being told that those rates aren't being accepted. Yet they were peer reviewed in St Mary's and those rates were accepted. So, and what I'm trying to say is Sydney Metro got it right in St Mary's, and I'd love to see it happen in the Hunter Connection where there was some sort of peer review, because it's not black and white. And that peer review, the experts got together and understood where they were all coming from, and we got those resolutions. But at the moment, we're getting take it or leave it approach.
And that's inside, I can only imagine, is creating some turmoil for your clients?
It's very distressing because at the moment they're finding it very hard to find where to go. And Sydney Metro's position is engage a tenant rep, and so we can confirm there's nowhere to go. And they know there's nowhere to go. But they want every client to engage now a tenant rep to prove that fact, which is, I can't see the justification.
And there's quite a few businesses that are affected by the Hunter Connection acquisition.
My understanding is 120.
So it's a large amount in just one building. That's fair.
Yes, and they're all small mums and dads who work very, very hard.
And very fine businesses, which I personally am a fan of. But the point here, Mr. Newhouse, is there any evidence of any behaviour change on behalf of the acquiring authority, in this instance Sydney Metro, which would disturb the view that they effectively are acting like behemoths who are beyond the law? Because that's the impression we're getting. As
I said to you, we're getting these reports. There's a range. They're picking the lower end of the range and they're not budging at this stage. Again, we don't know where it's going to head, right? But at this stage, they've made it very clear we've been told there's an internal policy not to deviate from the evaluation reports unless there's new evidence. Now, that's not what this is about, because it's not black and white.
So your evidence is just that the idea of genuine bargaining is foreign to the way they're behaving?
Yes, and if they had that peer review like St Mary's, we'd get a solution.
And Ms Sack, that's your view too?
Well, I mean, the same thing, that I think a peer review process is that just puts it just gives an opportunity for the experts to do what they do best, rather than feeling that everything's being, I don't know, I find it really difficult that the court requires experts to separately go and meet and try and seek to reach agreement on what they can agree on, what they can't agree on, that they're experts, they're being independent, but yet when they're experts acting for the resuming authority, they're being micromanaged and sat on and can't meet unsupervised with the other side or anything. It just seems so foreign.
My final question is just, I guess, much in the solutions vein. My colleague asked you a number of questions about how the Act could be improved, but the one question that I'm interested in is, do you think a resuming authority needs to be able to publish the reasons for why it needs to acquire property in the first place and set out its rationale?
One of the things that when you value land, you have to disregard the public purpose. So you disregard the uplifts associated with the public purpose. So if I'm living somewhere that is about to have the benefit of
like
a
Orchard
major
Hills, and it was about to get a massive railway station that's likely to see property values surrounding the station skyrocket.
then you've got to disregard. You've got to ignore that. The problem then becomes, well, what is the public purpose? Is the public purpose, so for example, you've had instances where you've had road widening projects, but they're then gone, well, actually the public purpose is urban renewal and rezoning. And you go, well, no, you're doing a road. That's your public purpose, not urban renewal. But so I think there is a danger, or there's a need for care in the way that the purpose or reasons for the acquisition are expressed, because obviously it's in the acquiring authority's interest to express those reasons as broadly as possible. So, for example, for Sydney Metro to say, actually, the public purpose, the reason for our acquisition is metro stations anywhere in Sydney.
Look, I know I did that final question, but the follow-up to that is one of the things which is unique about Metro as opposed to other acquiring authorities is that they are equally a developer. And I'm wondering whether or not that is, there seems to be evidence that perhaps that might be colouring their outlook on these matters, given that they are the ones who benefit more from the skyrocketing value than necessarily transport acting in this place.
It's very evident that the land that's going to be acquired will be upzoned for a different purpose in the future, and that the government is intending to reap the benefits of that and use that money to pay for its infrastructure projects.
That's what we used to term plunder, actually, I think. It was a government agency plundering a community for its value in order to extract the wealth and take it for itself. Is that incorrect, or is it too extreme a description of what we're hearing here?
I mean, that's the reality. Projects need to be paid for, but I think it then becomes incredibly difficult for owners.
It's too extreme.
Could I just
I think
say,
value capture might be another term.
could I just comment just on that one comment? What the biggest issue for my clients, and no doubt yours, is when they see the public purpose and they see these big towers going in these glossy brochures, and then they're offering a lot less, and they're offering these low amounts, that irates them. I know the public purpose is to be ignored, but when they see those glossy brochures or those videos on the websites, it does cause a lot of havoc. They're saying, but they're going to put a 20-storey tower on this block.
So, okay, sorry, we are out of time, but I do want to just pick up on that public purpose point. So the public purpose is decided by the acquiring authority, but then is presumably can be reviewed as part of the valuer general process, or is it a point of negotiation?
I mean, it just is.
It just is.
I mean, because in order to compulsorily acquire property, an agency can only acquire property in accordance with its powers of acquisition. So, for example, under the Roads Act, there are powers of acquisition in relation to roads. I mean, under the Heritage Act, there's even powers of acquisition in relation to heritage. So they have to be careful about the way they frame their public purpose, but it is something that a valuer is instructed to disregard. So they have to, there's a statutory disregard for the public purpose. So it becomes important to try and pin down, well, what's in the public purpose and what is happening that it's not part of the public purpose.
If ultimately there is a dispute over what the public purpose is, though, how does that get resolved? Do you need to actually...
Was it disputable, was the other question.
Is it disputable? Yes.
It has been disputed in the past, coming back to whether that acquiring authority had the power to make that acquisition. So there have been cases in relation to that which look at, well, what was the public purpose in that instance? And I mean, and that was where you had instances where there was we have an urban renewal project starting to be part of the public purpose of building a road, and so but it is something that you would need to go to the court.
It's highly technical, isn't it?
Yeah,
Very.
I failed many an administrative law essay on that point about ultra-vires. Right?
Any?
Yeah, it took me a few tests.
a couple of times.
Many. Excellent. All right. Unfortunately, we are out of time, but thank you so much for coming along today and giving us the benefit of your evidence. To the extent there were questions taken on notice, I'm not sure that there were, but 21 days to respond, and the Committee Secretariat would be in touch with any supplementary questions. Thank you very much.
Thank you.
Thank you.
Yeah.
Yeah. The Newcastle Herald is billing the toxic sludge positions of triple backflip, which I think is fair. Yeah, I can't sure it is. It's a fair characterisation in my view.
Okay. Welcome, Mr. Pearce.
Thank you, Madam Chair.
If I could get you to start by stating your name and position title, and then either swearing the oath or the affirmation.
I will. It's Matthew Pearce, General Counsel for the Inner West Council, and I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. I understand that Councillor Byrne is a late apology.
He is an apology, yes.
Okay. Thank you.
Always lovely to see Darcy.
Would you like to begin by by making a short opening statement?
I do have a opening statement prepared, so thank you for allowing Inner West Council to appear before the committee today. Council has made a written submission to the inquiry dated the 14th of July, expressing its concerns about the conduct of transport in the acquisition of land for the major projects in its local government area. I'll generally be speaking to those submissions. Inner West, as an amalgamated council of Ashfield, Marrickville and Leichhardt, has been impacted by a number of projects associated with WestConnex, the Sydney Gateway and the Western Harbour Tunnel. The acquisition process of the main transport projects have involved compulsory acquisition of council's freehold land, compulsory acquisition leases over parks and reserves for construction compounds, road acquisitions for road widening, land acquired where council is the Crown land manager over Crown lands. There have been various impacts as a consequence of the acquisition process upon council and its community. The impacts have generally involved the reduction of open space. As a consequence, as it now stands at this present point in time, there's been a removal or reduction of 9 parks or reserves in the LGA, so therefore the loss of recreational open space for the community. There's been direct and indirect financial impacts on the council's financial resources. And of course, there's been this near endless series of construction projects with associated noise, dust, traffic congestion, basically adversely affecting the amenity of the community. The conduct of transport during the acquisition process and the associated negotiations for these major transport projects can only be described as inconsistent, unfair, lacking transparency, and when I've spoken to some officers about their experience, they've described the negotiations as brutal. As a consequence of the conduct of Transport and Council's experience in this acquisition process, it is clear to Council that Transport takes advantage of the acquisition/compensation legislation, that being the Just Terms Act and other acts. The unfairness when it comes to Transport acquiring Council's parks and reserves and freehold land is twofold. Under Section 10 A of the Just Terms Act, the acquiring authority is required to make a genuine attempt to negotiate acquisition over a 6-month period before the compulsory acquisition process begins. In other words, the serving of the property acquisition notice, or in other words, the PAN. Council's experience is that the genuine negotiations really never happen with Transport, as it refuses to meet or exchange valuations to generally attempt to negotiate a reasonable outcome. There is under Section 56(3), which is the under Section 56, the relevant provision in terms of the market value, Transport takes the view that it negotiates only on Section 56(1) and nothing else. Council's position is that Section 56(3) of that provision is relevant because what the circumstances are that there is no market value for open space land, and so therefore Section 56 sub 3 applies. And the purpose is that, and the reason is that it's an important provision for Council because it's not a greenfield council. There's no other available space available, and Council says its position to Transport on each occasion is it's only plausible that if there's going to be replacement land, Council has to purchase private land. Transport disagrees with that. They just say it's simply the case of the willing buyer, the willing seller, and therefore the market value is based on that. There are other unfairness issues that have come to light during the acquisition process with Transport, and this concerns Section 206 of the Roads Act, and that particularly relates to compensation when Transport decides to acquire council roads for road widening. The issue here is that when Transport steps in and relies upon, seeks to acquire roads for widening for its major projects, Council insists that the compensation, as required by Section 206, must be based on some other process other than what 206 requires, in that Transport insists that we have to provide to Transport the cost of construction of these roads. As you know, Inner West is a very old council area. We have no records of the construction costs for these roads. It's an impossible scenario that Council has to deal with. But Transport continually insists, when it comes to road widening and acquisition of the local roads, that we have to provide this particular documentation as evidence for the necessary compensation. So the fallout of all this is that unnecessarily Council's had to take legal proceedings. There have been at least 2 instances where Council has taken Transport to court. When we go to court, all of a sudden Transport folds like a stack of cards because they do not want a judgment out there in the public, which may well go against their particular way they approach acquisition. So in summary, Council's, there are recommendations in the written submission, but in summary, the recommendations from the Inner West Council are that the legislation needs to be reviewed so as to create a level playing field for property owners and Council whose lands are being acquired by state entities like Transport. There needs to be proper planning by Transport for the delivery of major projects to reduce the impacts on the community. So in other words, not continuous major planning projects going on endlessly over a number of years. In terms of Inner West, this has been occurring for at least 5 years. The community is basically over it. Transport should also look at alternative sites for construction compounds, the subject of compulsory leases, rather than relying upon the council parks and reserves as the automatic default option. There needs to be one issue that has come out in the actual series of negotiation matters that we've dealt with is that for each compulsory acquisition, we deal with a different transport team. And we find that everything is completely inconsistent. So one team will take one type of procedure, another team will have a different way they approach the compulsory acquisition negotiations, and there'll be a third team won't even stick to the model at all. So we have one team at council, we deal with multiple teams over the number of years, and it's just completely inconsistent. There doesn't seem to be any set procedure within transport that actually that the council can comfortably deal with. Of course, more importantly, there's this whole notion of more transparency and open negotiations during the 6-month period as required by Section 10A of the Just Terms Act. What we've found is that transport just goes through the motions. In some instances, it refuses to meet at all. And nearly in all instances, it refuses to exchange any valuations with council. So we really don't know how they reason their market value for the land they wish to acquire. So that's a serious problem. And it's the council's position is that really transport does not make a genuine attempt to negotiate an outcome over the 6 months. And as a consequence, the council's general position is if the 6 months comes and goes, we're just not satisfied with any outcome that results from the negotiation process, we'll just refer it to the VG. Whatever we get back from the VG, if we accept that, fine. If not, we'll just go to court. That's our position.
Can I just clarify one point before I hand to you, Mr. Mookie? When you said that you've taken transport to court twice,
Yes.
And that they then just folded to avoid a judgment, does that mean that they then gave you a better offer? What did that look like in practice?
The one relates to Section 56(3) of the Just Terms Act. Transport basically said, before we went to court, they said, it's not worth anything. We went to court. The Valet General came back and said it's not worth anything in terms of replacement land to be reinstated. We got to the hearing. By the third day, Transport realised that things weren't going well, and they decided to open up the negotiations while the hearing was continuing. And then what happened was the offers started to flow from Transport. The offer they stuck on, the initial offer was started at, it's all confidential, it's a confidential agreement, but it started with a 6-figure number. By the end of the negotiations, in totality, it was 10 times that.
Wow.
Yeah.
So, okay, but how much did it cost council to, I guess, take that court action or to begin that court action? Putting aside the time, which was unmeasurable, the legal costs were in the vicinity of about $60,000 to $70,000. Right. Okay, so $60,000 to $70,000 to make Transport for New South Wales be reasonable, which obviously council has some access to, but the average person would find that very difficult.
Correct.
Yeah. Mr. Mookie.
Thank you, Mr. Pearce, for your evidence and the submission of your counsel. But basically, you're telling us that Transport is lawless and the system is broken. Is that fair?
I'll just clarify that. What I'm saying is that the Transport doesn't make that genuine attempt over that 6-month period as required by the Act.
So they're lawless?
So in one respect, they're lawless. I should point out that I suppose they were even more lawless because Section 10A, capital A, wasn't inserted into the legislation until 2016 or 17, And before then, what would generally happen is that we just get served with a pan. That was it. Now they have to go through this 6-month period, but the process that they adopt generally is that we get a letter, and the letter basically says, we've decided to acquire your land. No explanation why. That's, they've identified this particular parcel of land. And then they say, give us an offer. We have to go off and obviously negotiate generally, and we give them a valuation, and we say to them, well, here's our valuation, here's the offer based on the valuation. And then we say to them, well, can we have a copy of your valuation? They say no. And we say, okay, well, so do you accept our offer? No. And they'll come back with a low ball offer, obviously. Then we say to them, well, okay, under Section 10 capital A, let's start negotiating, let's get together in a room and start talking. No. We say, well, okay, well, if you don't want lawyers present or council officers present, what about the two valuers? Get in a room and try and work out an agreement of some kind in terms of compensation. They say no.
Which is quite extraordinary.
It is. And as I said, the council officers have explained it to me that the process is, from what they're experiencing, is a brutal process.
And just to be clear here, Inner West Council represents how many people?
I can't tell you that. I'm sorry. I think it's probably about 180 to 200,000.
And your revenue as well?
No, I can't. I'll have to take that one on notice.
But to give us a range? So 100 million plus?
I think you said you'd take it on notice. I think.
Yeah.
I'll have to, because I'll just say this. I've only started at Inner West Council.
My point
back
being,
in November.
if they can treat you like this, then what hope does a resident or a business have?
Obviously, no chance.
So what properties were they actually acquiring? Were they open space properties?
They were acquiring parks, large parks, small parks.
Which ones? Can you give us examples?
I think they're listed
Yes, I can.
in the submission.
I think it's in. Yeah, actually, it is in the submission. But one issue that's coming out of it is
Well,
that
can I just confirm that at point 12 you list a range of the parks, 9 parks or reserves. Are those the parks which you're referring to?
yes,
Right, yeah.
And they transport, how did they end up using them?
most of the parks have been used for construction compounds through their compulsory lease acquisition process.
And is this for the WestConnex projects?
WestConnex, generally for WestConnex, but also for the Sydney Gateway.
Yeah. So road projects. So there were
Yeah.
2 specific road projects we're
Exactly.
talking about.
In terms of the Sydney Metro project, the Sydney Southwest Metro project, there were lots of roads acquired.
Did you see a difference between Transport and Sydney Metro?
I can't answer that. I wasn't part of the process.
Can you take that on notice and
Yes,
see
I will.
whether or not your council officers thought that there was a distinction?
Partly because we have had evidence that it varies very much agency to agency.
And equally the time that people were having their properties acquired, I guess, is the other variation. But can I ask, just in respect to these particular parks,
Yes.
you made the point that there's no basis, there's no like-for-like sales, for want of a term, to actually get the valuation to benchmark. Was that the point the council was making?
Yes,
And you're saying that Transport just refused to acknowledge that reality?
that's correct. And in that instance, we've had to take them to court, and we obviously, eventually the issue was forced, where we did a commercial in confidence agreement in terms of the compensation payable.
Was it enough for you to be able to build 9 replacement parks?
I'll have to take that question on notice. I haven't got an answer for that.
But it's the case, right? It's not easy to build a park in the inner west, is it?
Oh no, and that's because
Dense.
that's right, dense population. There's always been a limited number of parks in and around those 3 council areas, and a loss of parks and the ability for council to use that compensation money to find other open space land is an impossibility. We have to buy private land, and that's obviously a costly exercise.
And a timely one as well, is it? It's not quick, is it?
Correct.
Otherwise, you have to issue self-start compulsorily acquiring properties, don't you?
That's right.
Have you? You have to compulsorily acquire properties?
Not at the moment, no.
Can I just go to those parks? You list them in point 12, some of those 9 parks or reserves.
Yes.
What's the total space that has been acquired between those? I'm happy for you to
I'll have to
that on
take that
notice.
question on notice.
Yeah, and obviously some of these will be part of the promise, and you refer to this later, is some of these will be returned to the community as part of these projects.
Yes, that's correct.
How does that amount of land that's been promised to be returned or has been returned, because in some cases there's a gap, compare to what's been taken?
Obviously less, because what is returned to us are what's called pocket parks, and they obviously are in terms of size less.
Well, I'm very comfortable for you to take this on notice, but it actually would be helpful. I'm not sure it is obviously less, in that there are some large spaces which will be returned, for example, around Rozelle to public parkland.
Correct.
So I think that head-to-head comparison, which I think would be unreasonable for you to provide now,
Yes,
would
thank
actually
you.
be helpful. I think if you were able to tell us what of these 9 parks, and I haven't seen this put all together before, what's the space here, and when all this is returned, acknowledging that's some significant way down the track, what's the space that will then be returned?
That's fine, the before and after.
Yeah.
Yes.
But equally, whether it's like for like too, because
Okay.
there's other
Yeah.
evidence as well about it's nice to have a park, but if it's sitting under a motorway, it might not be as airy as if there
Yeah.
wasn't a motorway on top of it.
Correct.
I think Rozelle, it's the other way around, isn't it? The park's on
True,
top
but
of
the St
motor.
Peter's Exchange, for example.
Fair enough.
Yeah.
And can I just then ask about 2 other elements of your submission? You make that point about often these will be coming back as pocket parks. In all but one instance, council is going to be expected to manage it, but the ownership is going to remain with the state.
That's
And
correct.
no money is being transferred
That's
from the
correct.
state to the council to manage it.
That's right. Transport insists upon care, control and management agreements that, and they say to us, well, if you want to have use of these parks, here they are, but you must sign this agreement, which is care, control and management, but there's no maintenance costs that go with that.
Yeah. So residents will pay for these parks to be maintained, but the council won't own them.
That's correct. But
Decisions about how they're built, not up to the council.
that's right. And the issue is that some parcels of land that are suggested by Transport to be given back to us under these care, control management agreements, some of those parks are contaminated.
Yeah.
And council sees that it should not be bearing the cost of remediating it to make it available for public open space.
For these 9 parks, for the land that has been, that will be returned, do you have an estimate of what those maintenance costs might be over time?
No, I don't. I'll have to take that on notice.
Yeah, if you could, I think that'd be helpful to give us some sense of
Yes.
even the scale of what we're talking about by way of maintenance.
And on notice, can you give us details of the parks or the lands that you'll be responsible for managing that may be contaminated?
Oh, I can do that, yes.
And I want to turn to one of those, which has been the subject of significant public discussion. That's the one at St Peter's Interchange as a result of WestConnex. That has been the subject of considerable dispute by the council for exactly that reason, the concern about the remediation costs of this land, the remediation responsibilities that go with this land. Can you give us just more of an update about where this sits today, given it has been the subject of a public arm wrestle?
I'll just have a look at this table I have. Otherwise, I might have to take that on notice as well, I'm afraid. It would appear that there's been negotiations and that the matter's been referred to the VG for a consideration. We've got a particular claim. Transport obviously has got a lower claim, and we're waiting for the Valuer General to determine it. Although we're not, it's going to take a bit of time because of the fact that the Valuer General is inundated
Sure.
with other matters.
When was it submitted to that Valuer General's process?
It was submitted early December 2021.
And do you have any expectation about when that process will conclude?
None.
Did you elect to go to the Valuer General because you had no confidence of reaching an agreement with Transport?
Correct.
And there's obviously significant issues here. This is a case where the site has been subject to significant slippage. There's a question over whether it's stable. There are also questions about contamination, and this would go to the heart of your concerns about care control and maintenance arrangements,
Correct.
but no maintenance funding.
Correct.
Even worse, significant liabilities. Are all those matters in the scope of the Valuer General's assessment? Are there some very significant issues? Will they all be dealt with in that process, or do some of those sit really outside of the jurisdiction of what might be settled?
Sits outside.
Right.
The Valuer General will only be concerned about the compensation, not the ongoing maintenance.
So all that may still be the subject of a separate arm wrestle.
Correct.
What is the process for settling that?
Well, at the present moment now, Transport is telling us to accept this care control and management agreement without compensation. We're saying to them, well, happy to take on board the care control management, but we need to settle on the cost of maintenance, or rehabilitation, putting in infrastructure as well, landscaping. We're not going to take it on at no cost.
And separately, secondly, the issue about who is paying for that contamination to be cleaned up, I imagine, is a separate secondary issue.
That's correct.
And a substantial issue.
Yeah, and no doubt there will be a long-running dispute about that.
And that's not settled at the moment,
Not that I'm aware of.
and it won't be settled by the Valuer General's process.
As far as I'm aware, it won't be settled by the Valuer General's process.
Can I just invite you on notice to provide any additional details that the Council feels are helpful to the committee in dealing with that issue? It has been contentious publicly, but in some ways it's the most symbolic of the other issues that you're referring to. And finally, I might just draw attention to the elements of your submission, and this is really just to draw attention to item 36, where you say, incredibly, there are generally no meetings between the acquiring authority council and their respective valuers in the negotiation phase. You've given us evidence on that. I'll just simply repeat my view. That is astonishing that that's the case. Thank you for that evidence. And secondly, your observation that there's a power imbalance during every stage of the acquisition, negotiation and post-project processes. Again, I acknowledge my colleagues' view that if the council, one of the largest councils in the state, is telling us that, what hope does a resident have in the face of this, what is a complicated legal process? I won't necessarily ask you to comment on either. Well, you're welcome to comment, but I won't press you to comment.
I'll just make an observation. One thing that is it's occurred to the council is that with the loss of open space in the council's local government area, and the problems of trying to, despite the fact that we might be given back some land, it might not be it might not be freehold, but we might get it back, care control and management. The issue is that we have, the Sydney Commission having a district plan for central Sydney, which includes...
Yeah, I was about to ask about this.
Yeah, which includes inner west. And the concern is whether or not, at the end of the day, when all these transport projects are completed, whether or not council is going to be compliant with the Sydney district plan in terms of the available open space in its local government area, in terms of walkability, access, things like that. And then I suppose that may well cascade down into the soon-to-be gazetted, I suppose, design and place SEP, State Environmental Planning Policy, which has also may have an impact upon development in Inner West as well, in terms of developers having to provide open space and matters like that. It's just a thought in the back of some of the council planners that, in another couple of years, how is that going to look?
Mr. Pearce, what is the Inner West Council's housing target currently?
I'll have to take that on notice, I'm afraid.
But it's a couple of tens of thousands, is it?
Yes, it's high.
So presumably you're expecting quite a large increase in your population over the next decade?
Absolutely.
And presumably people like parks?
Of course.
And that your existing park network is highly frequented, including by my children?
It is,
Yeah.
yes. It is.
I'm pleased to hear that.
And you're aware that there is such a desire for more open space in the Inner West?
Always.
And across all of Sydney? And
Always.
across the Outer West as well, you agree with that?
Yes.
And this has compromised your ability to meet the expectations of your residents?
Correct.
And equally, it's impacted on your funding and your financial base and your asset base?
Yes, I agree.
And that has then impacted on your ability to sort of borrow and all the other matters that are associated with a higher asset base versus the lowest basis base?
Yeah, that's right. There will be ongoing financial implications that the Chief Financial Officer has to deal with.
And as it is, you're still managing the financial consequences of forced amalgamation, are you not?
Yes, that is definitely true.
So to the extent to which the state government lowers what it pays you, your council's ability to absorb that financial loss is limited. Is that fair?
It is limited, and it will become, depending on what happens over the next couple of years, it's going to be quite finite.
How many properties are authorities are trying to acquire right now in the Inner West?
Transport, City Metro.
Western Harbour Tunnel, presumably?
Yeah, the Western Harbour Tunnel. That hasn't necessarily kicked off, but it probably will soon happen in the next couple of months.
So you're dealing with the Metro West project, the Western Harbour Tunnel project, the continuing impact of the West Connects project, particularly the M4 M5 link at the Rozelle Interchange.
Correct.
The Sydney Gateway.
Yes.
So these pretty major projects. Basically, all of them have their geographical nexus in your council rate.
Correct, and it's been going on for 4 to 5 years.
Just on that point, can I ask, do you think that is this? I mean, it is a little bit unique that the Inner West is impacted so heavily. Are there other councils that you believe will be experiencing similar pressures or not? Are you not aware of?
I can say this: prior to coming to the Inner West, I was at Penrith, and there was the pressure about the airport line in City Metro.
Yeah.
Prior to that, I was General Counsel at North Sydney.
Yeah. So similar pressures there.
Same pressures with Sydney Metro there.
Yeah.
Although most of that was underground, but there was still lots of building work going on and acquisitions happening.
Yeah.
Substratums as well.
Yeah. Thank you for that.
Are you noticing any improvements in behaviour by Transport or Sydney Metro in terms of the coming acquisitions versus past acquisitions?
It's consistently poor.
Is it getting worse?
It's just it's constantly poor. It's just as I said, it's a very, whenever we have to go into, in my past experiences in other councils, whenever we have to go into negotiations with the acquiring authorities, you have to put your suit of armour on and get ready for it. It's just, it's a tough, long, drawn-out process, a war of attrition.
Are you winning the war?
Sometimes.
And again, if you're facing yourself at risk of being, for want of a better term, conquered and or plundered, what hope is there for your residents and businesses?
It makes it difficult for everyone. Amenity, particularly for the community and their amenity impacts, and in particularly for Inner West, the shortage of always there's a shortage of open space. There's always demands for the community to have more open space. And what's happening now is we're losing open space at the moment. And what we get back is open space which we won't own in most instances. And then the transport will say enter into these care control management agreements.
So it is extraordinary then that we have a situation where there are so many acquisitions occurring between Transport for New South Wales and Council, but from what you're saying, you don't have it doesn't appear that you have a relationship with Transport for New South Wales. Is that correct? They're not the same team, they're not...
Correct. Each acquisition process we go through is with a completely different team. And as I said, they have different procedures, different ways they approach the negotiations over the 6 months. But constantly, it's always been that general procedure I told you about. We get the letter, we give them a valuation, they give us a number, but they won't give us their valuation, so forth.
Yep.
So it's constantly, when we know there's an acquisition coming through, we simply wait to see what team we get.
If it was the same team, presumably then there would be some learnings and some benefits of having an ongoing relationship in terms of perhaps making it a quicker process, do you think?
Yes, and it would make it more consistent.
Yes.
Yeah, and we would know what to expect, how to deal with it.
Thank you. Do you have any other
That's it.
questions? Any other questions from government members? Nope.
Can I just,
Yes, go
I
ahead.
just want to ask, in relation to this issue about the parks and the care control and maintenance, which agencies are you specifically dealing with in relation to that?
Transport.
Yeah, so that, okay, thank you.
And Metro?
Sorry?
And Sydney Metro, I presume?
Not that I'm aware of. It's just at the moment now it's just transport.
Yeah, thank you.
Okay. Thank you so much for coming along and giving us the benefit of your evidence. I'm still a little bit shocked that that's the experience of someone like yourself in council. And as my colleagues have said, you just imagine what it's like for a homeowner. That concludes the morning session. We're going to take a 1 hour break and we will be back at 1:30.
Thank you.
Okay.
Back to the afternoon session of today's hearing. If I could start by welcoming our next two witnesses. If I could get you both to state your name and title and then swear either the oath or the affirmation. Oh, they've already been sworn? Both? No, apparently you've both previously been sworn to this.
We're return offenders.
So you don't need to do anything. That's good. No swearing. Then I will start with questions from... Oh, no. Apologies. Did you want to have an opening statement?
No, Chair, we're fine to proceed.
Very good. All right. Thank you very much. Go ahead, Mr. Graham.
Oh, well, I'm not going to disagree with your first observation, Mr. Regan. An entertaining one. Thanks for reappearing in this forum. Firstly, I did want to put to you, where the committee's now received broad evidence about the operation of the Just Terms Compensation Act and some real community concerns. So there's a set of policy issues there. There's also some specific concerns that have been raised about the culture in Sydney Metro when it comes to acquisition, and I want to put those to you directly. The first of those essentially is that it has been, of the agencies, we're seeing a worse culture in Sydney Metro. That might be due to the fact that there's more contractors used. In putting that, I acknowledge these are important powers and they're necessary to do the work you're trying to do to drive this project along. But do you want to respond firstly to that idea that in the course of doing that important work, it is creating real stresses and pressures that are being faced by business owners or residents, and they are saying to us, this is worse with Sydney Metro?
Well, yes, let me see if I can attempt to address that. Certainly, I think as we've indicated previously to this inquiry, the approach that we take and the need to acquire property for our infrastructure projects is not something that we in any way take lightly. And in fact, we do acknowledge that it can be a very stressful and difficult process and time for affected property owners. We certainly do our utmost to minimise at the outset the amount of property that does need to be acquired. But I think as we've discussed previously, in order to build some of this infrastructure, we cannot entirely avoid the need to acquire property.
Sure. And that's understood.
So once we're sort of through that sort of hurdle of minimising the amount of property, we absolutely do our best to, within the constraints of the legislation and within the constraints of the powers that we have, try and reach agreement in a positive and collaborative fashion with as many owners as we can. And in that regard, I think the record does speak for itself that we have reached agreement. And I guess it is a difficult space because we do get lots of feedback that is
Mr.
positive.
Regan, can I perhaps put some specifics to you? I'll just put some very concrete issues to you that have been raised with us. Then I might hand to my colleague before I raise one other issue that I'm keen to get to. But I might just put these specifics to you and then give you the opportunity to respond to them. So one view that's been put to us in evidence is Sydney Metro was involved in valuations where the valuation never moved, the offer never moved, not a single dollar more was offered to landholders, despite the fact that the property market's going up so dramatically over this period. What's your view on that evidence?
Well, I've been taking that as a very general question. I can only respond to that in saying that we do, through the process, wherever we are able to get further information that our valuers take on board, we do adjust our offers. Obviously there will be specifics around certain circumstances where that may not have happened and may not have happened for good reason. So I guess difficult to answer in the generality, but certainly where there is evidence of market movement, where there is evidence of changed circumstances, it is our approach to, wherever we can take that into account, to do so.
The second issue is this, and I'll let you respond to it. Sydney Metro valuers were often ignoring their own planning advice and really relying on sales 10 to 15 kilometres away from the property. Now, that might be understandable in the bush. In the city, where you're acquiring property, it's less understandable. How do you respond to that suggestion?
Well, again, it's a general proposition you're making. Our valuers and the approach we take are intended and required to take into account all the relevant factors. And so I don't think there is any suggestion. I've certainly heard nothing to suggest in any circumstance that we would deliberately ignore properties in a proximity and look further afield. So I don't know the specifics, Mr. Graham, of that one. But certainly it's not the intent. Our intent is to try and find an evidence base, and where possible, if the market is moving, to try and find evidence to support that, that allows us to still meet our contrary obligation at times to also ensure that we are spending public money appropriately. And that I think is the hard part of this process, is that we have to find that balance.
And I think that's a very strong point. I mean, there is a balance to be struck here. The question we're grappling with is that balance right at the moment? I'll put one final specific to you, then I'll pass to my colleague. And this evidence has been given not just in relation to Metro but other acquiring authorities, that one of the things compounding the way the Act works in the 6-month process, the 6-month process is probably long enough, is one view that's been put to us, if it's a genuine negotiation. But what's putting pressure on that in part is the issuing of letters of offer 2 to 3 months into the process, that it means there isn't the full 6 months in practice.
Yeah, and I think that is one that I would say we understand the concerns in that area. A little bit of context, there is good reason why it can take time to get that initial offer out, and it is actually to try and assimilate as much market information, planning information, sales information as possible. So when these processes start, we don't necessarily have all of the information that we would need to be able to make an offer. So we do, at times, try and work through to take as much of that on board before making an offer. There are also circumstances where...
How quickly could you do it? One suggestion has been do it within 7 days. Is that realistic? Maybe not.
Look, I think it's case by case. And I guess, to use an example, where there are a large number of properties in close proximity to each other, it is clearly easier to look at those macro factors more quickly and to do that once. Where the properties are more bespoke, where there are smaller numbers, or they're of differing mixes of tenure or use, that is going to be more challenging. So I think, though, it is important, we don't then also necessarily adhere strictly to a 6-month limit and say that's it. There are plenty of times where we will then take a longer period, either to give parties more chance to negotiate. Certainly, I do understand the concern around the timeframes. I mean, we're working within the timeframes and the constraints that we're given, but sometimes more time helps. Sometimes I don't think it does.
Yep, sure.
Thank you, Mr. Regan and Ms. McPhee, for your appearances today. I think I probably should continue on with my colleague in putting to you specific scenarios that have been put to us to allow you to reply and respond and to provide some context. But did you hear this morning's evidence from Mr. Newhouse, by any chance?
No, I haven't.
Okay, well, Mr. Newhouse says that he's a solicitor who represents multiple people who have been in dispute with you and your agency, He says that his clients have appealed matters to the Valuer General for determination. I said probably shouldn't use the term appeal. Their clients have elected to proceed to Valuer General for determination. And the Valuer General, in instances, has ordered Sydney Metro to pay double what it had originally offered, which is astounding. Do you wish to respond to that claim?
Well, again, you're asking, to be clear, that's a very general question. So what I would respond and say is we do our best to get, with the evidence available to us, to a value. As we've talked through before, any property owner does have the right, if we can't reach agreement, to go to the Valuer General. The Valuer General then makes that determination as to the value. And sometimes that determination is very similar to where Sydney Metro was, sometimes it's very similar to where a property owner was, sometimes it's completely different. And there is, that's something that the Valuer General determines. And that's what the process is there for, so that the Valuer General, independent of both parties, can form a view. So there may be specifics where that has happened, but I think there would also be specifics where the opposite has happened, where the Valuer General has not reached the same view that Sydney Metro has.
Well, can I invite you to take on notice, if you can provide any further specifics to substantiate either of those two scenarios that you just described, that would be helpful.
Well, I think I'll have to see what I can provide. We don't go into the specifics of individual transactions.
Sure.
And I don't think that's appropriate without the agreement of an individual property owner for us to be disclosing that information.
Mr. Regan, at this point in time, I appreciate that, but we have a claim from a solicitor who's deeply experienced in the area who is saying that his clients are proceeding to the Valuer General, and the Valuer General is ordering you to pay double what you otherwise offered. And I'm inviting you to respond in whichever way you see fit.
Well, we'll be very clear that once the Valuer General has made a determination, we will honour that determination as we're required to do, unless the owner does not wish to accept it.
Sure.
And so it's a process element. The Valuer General will sometimes reach a different view to what the parties who were negotiating did. And you may have received specifics, but I'm not aware exactly which properties you're talking about.
Do you accept if the value doubles by the time the Valuer General's looked at it, that it was a lowball offer to start with?
No, not necessarily. So there are a number of factors that could result in the Valuer General coming up with a different view. And there are, for example, there can be particular elements of approach to the valuation as to what is taken into account and what isn't, that the Valuer General may form a different view to what our valuers have formed. It's not an effort to lowball. We have nothing to gain by lowballing and the process taking longer. Our preference is to reach commercial agreement on a basis that is value for money to the government.
Mr. Regan, in terms of going on with some of the specific matters that he's brought to our attention, in his submission he says, and this was as of May last year, he goes, more recently, Transport for New South Wales Sydney Metro has had more than 70 property and business claims referred to the Valuer General as agreement could not be reached. This should be a cause for alarm, as it would be the largest number of properties business referred to the Valuer General for a single project. Furthermore, many of these matters which did reach agreement were resolved only in the last month or even last days before Sydney Metro prepared its gazette's notices. Now, that's Mr. Newhouse's claim. Did you have 70 properties and business claims referred to the Valuer General last year in respect to any part of the Sydney Metro's projects?
I'll have to check the exact number. I'm happy to take the exact number for you on notice. What I would say is that the last year has been quite different to the previous years, in that Sydney Metro has been acquiring property for 2 metro lines simultaneously. So the number of properties we have been acquiring has also been significantly higher.
Yeah.
And you're referring to the evidence you received from a solicitor who represents some of those clients. I can get you the exact number, but I don't think that number going to the Valuer General suggests one way or the other whether or not our process is being properly followed. It is also reflective of what owners are seeking.
Well, Mr. Regan, again, I invite you to reply however you see fit, but it's a claim that's been made to us, and so I'm giving you a right of reply.
Well, as I said, I'll take on notice, unless Ms McPhee may have the number in front of her, but...
Yeah, I mean, I think it's probably worth noting that in terms of percentages across those two projects, more than 70% in both cases we reached commercial negotiations. So the number being referred to the Valuer General does relate to a small proportion of the very large number of acquisitions that we've been making.
Sure, and look, I do wish to unpack the numbers shortly. I'm just going to provide you the specific instances
so
I've been told.
On the question of how many are referred to the Valuer General, we're happy to take that on notice and we can get that exact number for you.
Yeah, and can I just say, for going on further to specific details that have been provided, Mr. Newhouse says that he represented, I think, a 12 was his claim, particularly in 5 Dock, and he goes that it's not, this is what he says, it's not only the sheer number of matters recently referred to the Valuer General that should be concerned of the committee, but the proportion of those referrals which relates to claims by land and business owners in 2 to 3 key locations in Sydney, being Burwood, Concord, Clyde and 5 Dock. Now, we've heard about the Clyde disputes, but the 5 Dock disputes are emerging, it seems. Can you give us an update? What's going on in 5 Dock? Because the way in which it's been described is that Metro's conduct there has been especially egregious.
So, no, I don't agree with that assertion. 72% of the properties in 5 Dock that we've sought to acquire have been acquired by commercial agreement and that is consistent with the rates that Ms McPhee just referred to generally. There are a number of properties in Five Dock, around 10, I believe, that we have not been able to reach commercial agreement on, which have gone through the compulsory acquisition process. So I think in terms of proportion, I'm not seeing that there is any significant difference there. There may be differences in view as to some of the factors around valuation. One of those factors, which is often a very material difference in view, is the value that is placed on the uplift in land value that the investment in the metro itself is creating. And the public purpose, as that's described in the Act, is not something that we can compensate owners for. In acquiring the land in order to build the infrastructure, we can't compensate them for the value of increase in land caused by that infrastructure investment itself. That can be a very material difference in expectation and what we're required or able to pay. And often there is a very significant misunderstanding that is not something that we are able to pay.
So I appreciate that, Mr. Regan. Just again to put to another claim to you, which I thought was startling, they make the point that Sydney Metro has engaged lawyers and town planners to identify technicalities under the Land Acquisition Just Terms Compensation Act. And they make this point that one specific result of this was that Sydney Metro has been particularly technical when it comes to compensating people who are leaseholders who are affected by acquisitions. And they say, for example, in recent matters, tenants who have had properties for 5, 10, 20 years were treated differently if they had a month-to-month lease versus those who had long-term leases. There was no acknowledgement by Sydney Metro of the history of occupation, but rather a reliance on technicalities to try to reduce compensation payable. Do you want to respond to that claim?
Yes, I would actually. Sydney Metro does not engage lawyers or consultants with a view to find technicalities in order to reduce the value that it makes of offers to buy property. We engage consultants and lawyers and as valuers as required to ensure we meet our obligations under both the Just Terms Compensation Act, but also our obligations more generally under as a public organisation to ensure that we appropriately spend government money. So we don't look for technicalities. There are often technicalities, if you want to use that word, around what different valuers or different lawyers may see as being the interpretation of clauses in those acts. And that is why there is a process where if we're unable to reach agreement, that a third party, an independent party, the Valuer General, makes that determination. Sometimes, the example I used previously around the public purpose is a very big cause of the difference. So we're not seeking a technicality, we're ensuring that the offers we make are based on appropriate basis so that we are fulfilling our obligations. If we don't fulfil our obligations when it comes to value for money, we are answerable in a different regard than to the Auditor General and the like. So it's this balance point. We are absolutely trying to find the right path between the expectations of owners and our own obligations, and we do that within the law.
Can I just clarify on that point? When we're talking about the public purpose, and as you say, you can imagine a situation where the value to sort of be discounted, I guess, would be very, very different depending on what the public purpose happened to be, and that the public purpose there could be multiple sort of contenders for that. When, as the acquiring authority, you're trying to establish what that public purpose is there a consistent sort of guideline or policy sort of document that governs that, or do you go for what you think is going to be the lowest cost to begin with? How does that work through?
I'll make a comment and then I'll ask Ms McPhee to answer that as well. So the public purpose generally that we're referring to that is excluded is the value of land uplift created by the investment of the metro infrastructure itself.
Yeah.
That's the specific. When we do analyse the value of a property, and our valuers do so, it's often done on a number of bases to look at, for example, the value of the property as is, the value of the property if it was redeveloped, the value of the property in different circumstances that or different valuation methods. And it is certainly not the case that we do that and then choose the lowest. In many cases, actually, the recommendation from the valuer is you could look at this a number of ways, but the highest and best use, or the highest offer would be achieved this way, and that's often where the offer is. So I think it's there seems to be a sense here from some of these questions or the evidence that you've been given that we're out to lowball. That isn't the case, but there is going to be a disconnect at times between what the owner of a property thinks it's worth or wishes it was worth and what our valuers say it's worth. And that's the challenge. But Ms McPhee may be able to answer, provide a little more colour on that.
Yeah, in terms of public purpose, as Mr. Regan says, we do limit the public purpose to the metro infrastructure itself and not broader government investment in an area. So it's very limited to uplift as a result of investment in metro.
So how many, I guess, if we were to try and get some sort of, get an idea of how many of the claim or the acquisitions that don't reach negotiation have to go to the Valuer General, how many of them are focused around that public purpose point, really?
I mean, it's hard to say. I think in some areas that has been the primary difference in valuation opinion, more than others.
Yeah.
I think you've probably heard plenty of evidence that certainly in a fast-moving, fast upward rising market, that becomes even more challenging because it's harder to delineate what the increase in value is for. Where there is a broad-based infrastructure investment or uplift taking place. Is it the metro or is it something else that's driving it? And that's sort of, I think, something we have seen on the Western Sydney Airport metro line. That's been a particularly challenging area because of that there's a lot of government investment going in, and what we're trying to do is isolate which bits related directly to our infrastructure, not the fact that the market is moving very quickly, which is due to a number of other purposes. So difficult, and I don't think we know the exact, because we don't know why someone doesn't accept.
No.
But certainly, we do see that sometimes in the valuation exchanges, in the valuation conferences that happen between the advisors on representing different parties, that is sometimes a key area of difference of view.
How many, and obviously take this on notice, I don't imagine you've got it in your head, but how many of, I guess, looking over the last, 5 years, say, how many of the acquisitions that didn't go ahead through negotiation but were then given to the Valuer General resulted in a much, I guess, a higher price being or higher value through the Valuer General than had been offered on the basis that the public purpose was viewed differently? So,
Chair, if we could definitely take on notice to see whether we can answer that. If we can't answer that specific question as to the public purpose, I think what we definitely can do is give you some further information on just that broad-based percentage itself, how many have come in at a higher or lower level.
As well, that would be useful, actually. Yeah. Sorry, final one, and then I'll pass back. Just so... No, I've forgotten what it was now. You go ahead.
Thank you. Mr. Regan, elsewhere we had other representatives from other people tell us who are representing those in the Hunter Connection. They described your conduct as being brutal, and that was the evidence that they gave us. And that they did not think that Sydney Metro was genuinely negotiating or trying to reach an agreement in good faith. That's another incident where effectively the same claim is being made against your agency. So do you want to respond to the claims we've heard this morning about the way Sydney Metro is engaging with the Hunter Connection businesses?
Well, what I would say is that is certainly disappointing if people are suggesting that we are not behaving in a professional or appropriate manner, because that everyone who works for Sydney Metro and contracts for Sydney Metro, we expect the highest standards of behaviour. So I don't know whether that is the suggestion.
No, the suggestion is that you're being hardline actors who aren't there to negotiate, who are turning up to meetings and explicitly saying this is not a negotiation. And that is the way in which that conduct, or that some of that conduct has been described, was brutal.
Well, I think we need to also take into account where we are in that process. So the Hunter Connection and the other property acquisition processes in the northern Sydney CBD are progressing, and we are at a stage where we are having discussions with parties but also providing valuations where we can. I think we need to be careful because some meetings that are set up to explain how we've got to a valuation or to where we are in the process are not negotiations. It doesn't mean that we are not willing to negotiate, but actually where there are meetings between, for example, the valuers for each side of a negotiation, some of them are specifically set up to exchange information between valuers to allow further information to be taken into account. That of itself is not a negotiating meeting. So I do make the observation that it is possible that things are being taken slightly out of context. We are going through the process as we're required to do and as we seek to do to try and work through those steps to get to the point where we can reach commercial agreement with as many parties as possible, and that applies in the Hunter Connection as well.
Mr. Regan, look, I accept that that is the view that you're putting, but see, the problem that we have is that incident after incident after incident amongst people who are not coordinating with each other, who are all disparate, who are all engaging with your agency, are all pointing to the same problems. We have had the families from Orchard Hills. We've had the businesses of Clyde. We're now hearing about the businesses of Five Dock. We're hearing about the businesses of the Hunter Connection. And they're all making the same claim, which is basically your agency acts like a Goliath and that they can't deal with you. Now, if it was one incident or two incidents... I would
appreciate if actually that is the claim that they are all making, if we could be given more information on that, that would be great. Because, as I said before, we are acquiring a very significant number of property interests. In the Hunter Street area alone, there are 11 buildings where there are 500 property interests. It is a very difficult process, a very difficult situation where we are acquiring the residents or the commercial premises, particularly of individual owners or small business owners. We recognise that is difficult, and we do get into situations where people are very unhappy because they are unhappy we are buying their property, and that's a hard place to start from. We also get commentary which probably may not have been given in evidence to this inquiry. We do get a lot of positive feedback as well. So I think the suggestion that all of those owners are making those allegations about Sydney Metro, I would like to know whether that is actually the case, because that's not the information that we have.
Well, Mr. Regan, I invite you to read the evidence that they've given to us, the testimony that they provided throughout this inquiry of all their submissions. I mean,
yes, but that is only a fraction of the parties that we have engaged with, and that's the point I'm making, that a lot of those properties that we have acquired, we've acquired by agreement, and some of those property owners have told us they've been very pleased with the process. So it is clearly more difficult when someone is not happy with where it's landed, and they are, in that case, open to seek alternatives, including
Mr. Regan,
the way the process is set up. I'd be more
open to accepting that view if the weight of evidence wasn't that there are more issues with Metro and with the culture that exists.
Well,
and that's really, I mean, there's significant acquisitions going on, including many road acquisitions. We've had less evidence raised with us about those. I accept the work you're doing is of very large scale, but it is causing more community concern.
Well, as I said, the percentage of properties that we've acquired by agreement still remain quite high, and the number of properties we are acquiring has been at a peak because of the two projects that we're acquiring for at the same time. So, I hear what you say, but certainly we are genuinely focused on trying to reach agreement with as many as possible. And the fact that we don't reach agreement does not necessarily mean that we have not behaved well.
Mr. Regan, you made the point that you were giving us some statistics before about the numbers that you have reached by agreement. I think you said 70%, was it?
Yeah, that's correct. 70% on the Metro Western Sydney Airport project and 73% on the first stage of Metro West.
Yeah, well, Mr. Regan, let me put this to you. One of the analysis that's been provided to us, and it's from BT Legal, who have looked at the figures. They say in the 8-year period prior to the commencement of Section 10A, there were 2,970 reported acquisitions in New South Wales, of which they say 85% were by agreement. In the analysis that they've done of the acquisition since the commencement of Section 10A, they've said 84.7% are reached by agreement. So the issue that we've got, right, and to be fair to them, that they are the first people to provide us with this analysis. And as far as I'm aware, it's the first type of analysis that I've seen on the issue. Now, if we were to accept their view that 85% is the benchmark for reaching by agreement, it does seem, even with your figures, you're well below it.
I would disagree with that. 95% of the properties on the Northwest Metro were done by agreement. So,
Okay, well, it's 95% on the Northwest Metro, but you're on 70 and 73 on these ones.
Yes.
So
there are different circumstances on those projects. I'd be very happy, if it would help the inquiry, to provide details of the percentages by project that we have acquired by agreement or have gone to the Valuer General.
please, and if
Can
you
I just
could.
pick up on this point for a sec? So, in terms of the Northwest Metro and the record there, the 95%, what is so different with these two projects that's got them sitting at 70 and 73%?
So there are some significant differences. Certainly, the acquisitions at scale in areas where you have high proportion of strata occupation, both particularly in the retail or commercial space, are very different. So in the city, around the Hunter Connection, around the buildings around Hunter Connection, that's a very different environment to when you're acquiring
Greenfield
property,
site, effectively.
a greenfield site, for example. And in the city, in that circumstance, there are 11 buildings that we're acquiring for the Hunter Street Metro Station. There are over 500 individual property interests in those 11 buildings. So it is a very different challenge and circumstance, both in terms of volume, but in terms of the type of owners and the ability for those owners to relocate as a greenfield site. There have been other areas where we have achieved a lower rate of agreement, such as the Orchard Hills area, where around 50% of the properties that we acquired were done by agreement and 50% have gone through to the Valuer General. That was particularly difficult as an area, and we're not talking about a large number of properties, but for the individuals affected, it's still a very, very significant and difficult process that we understand and acknowledge. The challenge there has been the very significant growth that's going on more broadly in the area, and a lack of perhaps a agreement or understanding as to, in some cases, why those properties were being acquired, which has created a different circumstance, and that they are quite unique properties. When it's been harder for people to see what alternative they might have to them. So I think it is a bit case by case. In some areas, there's been a much higher success rate. Perhaps it's big where there is more fungibility of property, for example, that people can move to. I can't really speculate why it is different in different areas, but there have been individual factors that have impacted it. And I think we've found that generally, and we haven't finished, to be clear, the acquisitions for Metro West, and so we may well still end up at a higher percentage than where we're talking about before. So
just on that then, we're sort of using the idea of, percentages of properties acquired during negotiation as a measure of perhaps some sort of success or whatever, which clearly it's not. There are many reasons why people might accept or not accept the offer. Do you do anything in terms of surveying, like in terms of a satisfaction survey or some sort of data collection to see what people are thinking after the process? Is there any kind of surveying done?
I might ask
So we do a lot of broader community engagement surveying, but I'm not aware that we do specifically with the acquisition process, but I'll take that on notice.
I think we could look into it because the Centre for Property Acquisition does have those personal property managers and does set some stands out and does, I don't know whether they do specifically what you're asking, but certainly we could look at that.
Because that would be obviously very useful data to then guide and to work out if there are approaches from particular agencies that are problematic. Could I ask, though, how many of your sort of acquisitions are done by external parties rather than sort of a permanent team within the agency?
So we do use a combination of sort of permanent staff and external parties. Certainly, the challenge with Sydney Metro's acquisitions is when we do acquisitions for a line, there are, as we've discussed, a very significant number. But certainly we would not have that volume other than when we're at the front end of a new project, which at the moment we happen to be at the front end of two. But by the end of this year, for example, most of our property acquisition processes will be done for some time, potentially, unless there is a further new metro line announced. So we don't maintain a team of people, permanent staff, to match that surge capacity. We probably, relative perhaps to Transport for New South Wales, need to supplement that further. That said, the decisions around the offers and the approach taken are still decisions taken by Sydney Metro employees. So we do use third-party advisors and valuers and contractors to supplement our capability to manage the processes, but the key decisions are still made by staff.
And so a third party is involved in the actual contact with individuals who are having their properties acquired?
In some cases, that's right, yes.
What assurance do you have then that those parties acting on your behalf are carrying out those acquisitions in the way that you would hope that they are?
Oh, and certainly, that, as I said before, we absolutely expect the highest standards of behaviour, and if we get feedback that is not the case, well, then that's something that we look into and address.
Perhaps another thing that a survey would identify for you.
Potentially, that's right. Yep.
Thank you.
We do also undertake assurance reviews and audits of our processes as we go through. The last one of those was completed in February last year, but that is obviously more focused on how our staff are applying our standards, policies and procedures in accordance with the Act. So we do a retrospective check on how well we've applied the legislation that we're operating under.
Yeah, but not what it feels like to be a person on the receiving end.
No.
Yeah.
Can I put you, just take you to another matter, Mr. Regan, which I guess is similar and connected. Sydney Metro is active in the community of Narellan, aren't you?
Narellan?
Yep.
I don't believe we're undertaking acquisitions in Narellan. When you say active, do you mean undertaking acquisitions?
Is Sydney Metro responsible for land near Narellan being rezoned as special purpose infrastructure, allowing the development of a train station?
So Narellan is, I believe, on a future corridor. It is not part of the current corridor. And Metro itself, Sydney Metro, is not a party that's responsible for rezoning. So I'm not sure I understand.
So are you the
your
beneficiary
question.
of that, or are you intending that corridor being reserved for Sydney Metro or not?
I believe that may form part of potential future extension to the Metro Western Sydney Airport line, but that is not something that we're actively proceeding with at the moment.
But the problem is that as a result of the special purpose infrastructure rezoning, 19 people have been told that 19 landowners have been told that there's a possible compulsory acquisition of their properties coming, but they haven't heard anything since. And this took place 2 years ago. Do you have any response to that or any knowledge of that?
I'd have to take that on notice. We have no investment decision. There's been no decision from government to build that section of rail line, so I'm not aware of that, Mr. Mookie. I'm happy to take it on notice.
Because the problem is of course, this effectively rendered their land untransactable. And because now its zoning has changed for a corridor development ahead of it.
Yeah,
clearly, as you say,
as I said, I'll have to take it on. I don't believe that is a Sydney Metro activity, but I'll take it on notice.
But and I'll just confirm it has already been rezoned. So as a result of its rezoning to preserve the corridor, I presume it's rendered the land again unsellable.
I can't comment. I'm not aware of it.
Okay, fair enough. Can I just take you to? I was hoping to get, before I pass to my colleague, just a very short update on the number of acquisitions which are still pending for the two lines.
Yes, if you could just give us a moment.
So,
When you say acquisitions still pending, do you mean acquisitions still to be determined?
Well, acquisitions you'd like to make that are yet to be resolved in however way you describe, whichever method of resolution.
Yeah. No, sorry, I was just checking what you meant.
So I think it's probably best if we take that question on notice, because we've got a mix. We've got a mix of acquisitions which are for the Pyrmont and Hunter Street stations.
I'll take any.
Yeah.
any information you've got to hand right now will be acceptable, with the opportunity to supplement it by notice might be a better way to proceed if it's possible.
No, happy to do that. So for Metro West, we are in the offer and negotiation process for Hunter Street and Piermont, which I believe I do. Here we go. Yes, I do have those stats. So that is a total of 513 interests, as Mr. Regan has mentioned previously, across 13 buildings. That's across the two stations. Then for the other two, so Metro Western Sydney Airport and the first stage for Metro West, there are a number of issues which are with the Valuer General or at the Land and Environment Court, and I'm afraid I'm going to have to get back to you with those specifics.
Okay, but how many are you still... Is that, as you're saying, all of the remaining acquisitions are now with the Valuer General and or the Land and Environment Court?
Correct, will have been agreed.
Other than the ones at Piermont and the city, the majority.
Right. And how many have you, for Metro West, the initial section, have you achieved by agreement? Not by number, not percentage.
Yes, we'll just bear with us, we have that number.
So, sorry, I'm doing some maths. 298.
Do you know how much were the target for that section in total?
The total number of acquisitions,
Yeah.
417, and that's interests.
So we can interests. Okay, so we can include that the difference between 417 and 298 is the number that are either before the Valuer General and the...
Some have since been agreed, either acceptance of the Valuer General
Good enough
determination.
range for us to understand how many are still outstanding.
Yeah, so at this stage, 72% have been concluded by commercial agreement, and so the outstandings are around...
So of the remaining 119 for Metro West, 60 of the Valuer General determinations have been accepted.
Okay, I'll pass to my colleague.
Great, thank you. I just want to turn to the Orchard Hills question, just to one aspect of that. So the committee went out there, talked to the residents. I understand there's a whole set of issues here, but one thing that was quite persuasive when you looked at the site was there's a small space required for the station, perhaps a slightly larger space required for construction, but a much larger space again, which is being acquired for the site. That's
not correct. The third bit.
Well, I have to say, standing on the site, it really did look like that.
No, well, so I think I've described to the inquiry before, the land that's being acquired at Orchard Hills is entirely for the station and the construction of the line. It does include a very intensive construction facility and site over about, I think it's 27 or 28 hectares, similar in size to the parallel site at Bella Vista, where the same works were undertaken for the North West Metro. And all of that site will be used for the construction.
So you stand by those comments?
I do, yes.
Can I ask you, sorry just to interrupt, but Mr. Regan, the issue that the Orchard Hills family raised was accepting that, you, as you say, you needed it for intensive construction. Why didn't Sydney Metro just pursue a lease as opposed to a permanent acquisition? Because their point was, well, we'll give you the lease, we'd just like to come back to the land when it's done.
Yes, I believe we went through this in detail in the previous hearing.
And we're still struggling with the answer.
No, that's fine. I'm
really,
I'm happy to go through it again, but we did go through this in detail. The land will be materially and significantly changed, and the individual holdings that are there, once this is in a full construction site, will be significantly and permanently altered from its current circumstance, from its current configuration, and therefore it is not a matter of just handing back a piece of land that would have any similarity to what was there in the first place.
I think the key, you're comfortable with the position you previously put is really what I'm hearing.
Yes, so the land that we're acquiring is for the purposes of the railway and the construction of the railway, and it will be intensively used, and the nature of that land will be changed.
I might move to this issue. Back to the Hunter Street acquisitions. The government and Sydney Metro have made clear that Hunter Street Station, when it's redeveloped, will be part of the revitalisation of the CBD. There's big plans for what might be there. Just give us a brief description of what you might see there for the public aside from the transport infrastructure, food and beverage, entertainment, what's envisaged for that station as it's rebuilt?
Yeah, so the Hunter Street station has two key areas of impact at the surface level, and with entrances around the corner of George and Hunter Street, and then further along to the east on Hunter Street between Bligh and O'Connell Street. So there's two areas where we're acquiring property for that station. That particular part of the city, as you know, is a very busy part of the city, and essentially commercial activities predominate in terms of the buildings at the higher levels, and there is a lot of retail, food and beverage retail and other retail around the ground level. What we're doing at Hunter Street is the station, which will connect those two sites underground, and then it also connects into Martin Place and Wynyard. We expect that there would be a mix of retail and station-orientated retail around the station itself, and then there is a very significant opportunity for integrated or overstation development, which we expect would be a mix of commercial buildings on top and around, but with a very significant focus on the ground level placemaking opportunity that it brings. And some of the buildings that are there at the moment, are buildings that have been there for some time. The opportunity to reshape and redevelop that area with a more open, public-facing, public-orientated ground plane and above is pretty challenging to deliver, but a very exciting opportunity.
One of the businesses that's operating there at the moment, one of the key music venues in the city, is Frankie's Pizza by the Slice.
Yes.
There's been some public concern about what happens to that. Where are you up to in the process with that specific business?
So I'm not sure where we're up to with the specific discussions with the owner of that business, but I could look into that, although I won't be able to come back with the specifics because we're in that early negotiation phase.
Well, my previous questions were too general. I'm now being quite specific.
Yes.
I was hoping you could tell me something about this, in part because the former Transport Minister promised publicly the venue will be looked after and relocated.
So I will take on notice to see whether I can give you a specific update. I don't know where we're up to on that actual site.
Can I put my concern to you, though, Mr Regan, which is this. This is what the Minister said. Frankie's is an important part of the Sydney live music scene. We'll make sure it's properly supported during this challenging time. Sydney Metro is assigning Frankie's a dedicated acquisition manager to guide them through the process. Now, the Minister's promised this will be looked after and relocated, which will not be
the former
easy.
minister. I take
the
it.
former minister. A strong point. A strong point. Have they been allocated a dedicated acquisition manager?
I'll check that.
Perhaps do you want to check that with Ms McPhee, who's nodding?
All of our properties we acquire.
Right, so that's a routine part of the process.
So we can come back and confirm that. I don't believe that any transaction has been agreed on that site, so I'll see what I can come back with in terms of detail. And I understand your comment.
A less routine part of the process is that they'll be looked after and relocated. That won't be easy. We've already lost 176 venues in the CBD after the lockouts, and it's because of the conflict in use in the area. It is difficult to find places for these businesses to operate, sometimes because of the sound issues that arise. Can you give us any guarantee that the former minister's promise, now the former minister has departed the stage, will actually be adhered to?
Well, I'll have to look into where that specific one's up to. I understand your question. There's certainly been no decisions made around the individual use of the sites in terms of the mix or the individual tenants in the future. I mean, we're a long way from that. But I'm happy to come back with any further information I can give you.
But is it a possibility that in the rebuilt Hunter Street station, in the sort of the placemaking, ground level placemaking that you've described, there might be a place?
I think it's quite likely that in the scale of the opportunity that exists there around and the type of activated placemaking opportunity that exists, that there would be a mix that would, be targeting, not just sort of people quickly getting a coffee when they get off the train, but people who want to be there in the evening, be it for a music venue, be it food and beverage. I think there's probably going to be a demand for all of that. Yeah. So we haven't made any decisions. I'm not being defensive about it. There's just no decision made. But absolutely,
it's not off the. That is not off the table. But
no, absolutely not. And what we're seeking at the moment from industry is ideas on what they would like to do in that area in the context of that placemaking. So we've put that out for a response from industry, and I think there's an incredible opportunity.
But you've taken on notice the specifics, and that is acceptable. But there's no guarantee at the moment that minister's promise that it'll be looked after and relocated, acknowledging how difficult that might be. I mean, that looked after and relocated for a venue like this, a very specific use in the city when we've lost so many music venues.
I'll have to see where it's up to, but I understand the question.
Will not be easy. Acknowledging that, that sounds more expensive than your usual process, I have to say, Mr. Regan.
Well, I think what I understand, different parts of different landowners around that area and different sort of parts of the placemaking sort of thinking that's going on would be looking to create a very lively, thriving precinct that would have a mix of use, including exactly the kind of venue that Frankie's was. So, I'm not able to give a specific answer on where we're up to, but I absolutely understand the question, and we'll come back and see what we can give you on that.
Thank you.
Mr. Regan, can we just return a bit to, I guess, the size and scale of the acquisition of land around Orchard Hills? Once you do complete construction and the station is built, is there going to be surplus land to the station?
Sorry, what do you mean?
Well, once you finish constructing the station at Orchard Hills, is there going to be surplus land in the surrounding area of the station?
During the, as I said, there's a station and an alignment for the railway that's being built, and that will obviously be the railway land in the future. Some of the other construction land as being used to construct the railway will then form part of the precinct around the station. So
who will own that?
Well, that land is owned by Sydney Metro.
And so you, because you're also equally under the law, you're a developer, are you not? You've got the ability to develop.
The land I was just describing around the station, so access for cars, for buses, for active transport, the general precinct around the station, which is not part of the station itself, but that transport precinct then forms part of the transport interchange. And then the broader land beyond that, the government has announced the intent that that area of Orchard Hills will have a town centre and be a sort of a mixed-use precinct of activities, which I expect would include community, public use, residential, commercial.
But Sydney Metro would be the owner of it?
At the moment, Sydney Metro as the acquiring authority owns that land, but no decisions have been made around the development of that land and which entity or which part of government, noting that the land will also need to be rezoned, will be doing that. So that's a decision for the future.
Sure, I accept that it's a decision for the future. When's that last line meant to open again? In 4 years' time?
So yes, the airport is due to open around the end of 2026, and
sure.
we're running in parallel with that.
And so in 4 years' time, your organisation and or the government will face a question as to what to do with the land, correct?
Yes, and I expect we'll be working, as we have been, with the other parts of government well in advance of that, to ensure that the area along the whole alignment and the future use of that area is something that people are working through at the moment. There's a planning process, a rezoning process. It is certainly preferable for our metro stations to open into activated precincts rather than to open with that development.
So when you say, Mr. Regan, that this is a matter for the future, really, it's all the work has to commence as already has commenced. That's correct?
Well, as I said, agencies across government are doing that work. There is a DPE will be leading a planning process.
But as Sydney Metro, do you have a financial target as to what income you're meant to earn off the land that you will own afterwards?
At Orchard Hills?
Yes, we'll start with Orchard Hills.
No, we don't.
What about across your whole portfolio?
In some parts of our portfolio, we do.
And so presumably once you do finish the station, of course, you're not going to be expected to simply keep the land idle. You agree with that?
Well, the government, I think, has already been quite clear that it intends those areas of the Metro West Sydney Airport line to serve integrated precinct township type developments. So that's on the record.
But the Metro organisation was set up with the powers it has, so it has got the ability to effectively mimic a model which is available in other jurisdictions. I'm not questioning it, which is the ability to equally do the wider precinct planning and capture some of the value uplift for the public.
Yes.
You agree with that?
Yeah, so and in parts of the Metro portfolio, we have been tasked with doing that, and in recovering part of the value of the investment that the government has put into the infrastructure by developing the surrounding land, and that comes case by case though.
Indeed, but it's part of the Metro model, is it not, to help reduce the investment cost of building the lines by being able to also benefit from the uplift that the lines create?
It is different between the different lines in terms of the financial arrangements, but yes, Sydney Metro is set up with the ability to facilitate the broader activation and development of precincts around its stations.
And that is to help pay for the building of rail lines, correct?
Absolutely, and in the within our portfolio, we do have a significant area of our funding source that does come from development of those sites, including some of the northwest and the city and southwest, and that's sort of including things like Martin Place and Victoria Cross and the Waterloo housing development. So that does form part of the funding arrangement for Sydney Metro. Yes.
So one of the views that's been put, which I want to give you the opportunity to respond to, is that then creates commercial incentives for Sydney Metro to acquire the land at the lowest possible cost in order to maximise the return on land into the future as well. And then part of it is what's driving Sydney Metro's behaviour on the airport metro line, Western Metro. Now, it's been made by, again, numbers of people who have said that because you are a developer as well, or you have the power to develop and you have a part of your financial model to pay for the rail line is to exploit the wider value that it would create and capture some of it. That is creating a conflict, and that is part of the reason why they describe your culture as being commercial and hard line. Do you want to respond to that?
Yes, I will. So I think there are two different issues. Firstly, when it comes to acquiring land, particularly the use of compulsory acquisition powers, our powers are quite limited, and they are limited to the acquisition of land that we need for the construction of the railway. And that is important because that is what we do. And as I was describing before, we limit our acquisitions to the land that we need, and we try and minimise the land that we need. When the railway is built and that purpose has been fulfilled, if there is surplus land, then it is in certain parts of our portfolio part of the financial package that we're operating under, that we are required to seek a return on that land post the development of the railway in order to contribute to the cost of building Metro. But they are quite different phases in the process.
Sure,
so I don't agree with the assertion that the fact that we do sell surplus land means that we have any conflict at the start when we are under a separate and very clear set of obligations as to what land we're allowed to acquire.
Sure, but Mr. Regan, I guess if you were to be benchmarked to a private seller of land or a private developer of land, a private developer of land can't use compulsory acquisition to acquire the land that they then on-sell. They have to buy it in a commercial setting. Now, of course, the Act encourages you to do the same, but the difference between Metro and a developer is that a developer cannot trigger, for want of a better term, eminent domain, but you can. And that's why your agency is unique as a developer, because no other developer is capable of using the Crown's powers to forcibly take land.
I think we need to be a little bit careful in making that connection, because the vast majority of land that we buy is for infrastructure and is not developed. What we're talking about here, and you asked around if there is surplus land after we have needed land for construction, what do we do with it? And in relation to Orchard Hills, we have not been set a financial target, and we do not have financial targets on that line for property development or returns that we're required to generate. Elsewhere in our portfolio, where we do seek to recoup part of the investment, the value of having already purchased the land and demolished the buildings that are on the land before we get to the station also has to be taken into account. So we're contributing to the cost of the infrastructure, but we are not, in doing so, we have to spend a lot of money to get to the point where we can seek to recoup part of that investment. And so they're quite different functions, and they're performed at quite different times in the program of a delivery of a railway.
Fair enough. I was just going to ask for a short update, and I think you may have made a loose reference to it when you were giving us some statistics around the Piedmont acquisition, but you are still intending to acquire land that belongs to Star City, are you not? Or the Star?
We have a station site that has been that's publicly available in Piedmont, which is where we're looking to acquire the station.
Well, there's a tension here, and again, it's a land use tension similar to what my colleague was describing with Frankie's, albeit on a larger scale, in which some of that land has been earmarked for the development of 6-star casinos to help boost our tourism industry, or elsewhere, or 5 stars hotels, I should say. 6-star hotels. I'm not sure there is a 6-star casino, but either way, can you give us an update as to where you're up to in terms of that particular acquisition? Is that one that's been gone to determination, or is that one that you're still negotiating?
Yeah, we're still negotiating on that site.
When are you meant to have this all wrapped up? Not all of these acquisitions around people.
Well, we're negotiating on that site. We're looking to conclude those negotiations this year.
Fair enough.
Okay, that is all we have time for. Thank you very much for making yourselves available again for our questions. In relation to questions taken on notice, 21 days to respond, but as per usual, the committee team will be in touch. Thank you.
Thank you very much. Thank you.
I'm happy to kick off, but then I'm going to... What do you think you've been called? What have you got?
What's the next one?
What should you be telling us? What would you ask if you were in our position?
Would you like to expand on?
Thank you. So we now welcome our next witness, Mr. Plowman. If I could get you to please tell us your name and position title, and then either swear the oath or the affirmation.
Okay, thank you. My name's Paul Plowman. I'm the General Manager of Asset Lifecycle at Sydney Water.
Do you mind using the microphone forward, please?
How's that?
That's better. Thank you.
Would you like me to repeat?
No,
Justin?
go ahead. That's fine.
Affirmation, I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Do you have any opening statement you'd like to make at this point?
I do. So
Please go ahead.
I'd like to thank the committee for the opportunity to assist in this inquiry. On occasion, Sydney Water does need to acquire land or easement to build or upgrade water and wastewater infrastructure. The location of land acquisition is driven by the nature of the assets and the proximity of the catchment that we need to serve. Where property owners are directly affected by a proposed project, we try to contact them as early as possible and let them know about the potential impacts and the process that's about to begin. Sydney Water's property acquisition process is in line with the legislative obligations that are expressly outlined in the Sydney Water Act and also the Land Acquisition and Just Terms Compensation Act of 1991. In the first instance, Sydney Water does seek to contact impacted landowners, notify them, offer to purchase the land and commence negotiations. If an agreement is reached, the acquisition is finalised and Sydney Water compensates the affected owners for a reasonable valuation and legal fees. In some cases, Sydney Water may need to compulsorily acquire land under the Land Acquisition Just Terms Compensation Act. Sydney Water will always continue to try and negotiate with property owners throughout that process. In relation to Transport for New South Wales, subject of this committee, Sydney Water works with Transport when projects overlap and land needs to be acquired by either party. Sydney Water and Transport utilise the Treasury Directive for the purpose of determining compensation payable between parties when undertaking that acquisition. On behalf of Sydney Water, I hope to assist the committee in its inquiry as the best I can.
Thank you very much. I'll start with Mr Graham.
Great. Thank you, Mr Plowman, for that opening statement. In the course of this inquiry, the committee is looking both at the general issues that affect the Just Terms Compensation Act or acquisitions in the style of which you've just described. It's also looking at some specific sites and issues, and one of those is the development centred around the Sydney Science Park and related issues. It's really in that capacity that a request had been made for a witness, and Sydney Water's recommended you should appear in place of that witness, as I understood it, but feel free to correct me on that basis. Can I just turn to that, the set of issues around that development, and just ask you to give us some background. I'll turn first to really the moment on the 17th of December 2020 where Sydney Water announced, or the government announced with Sydney Water, a landmark partnership for this site and an investment for significant water infrastructure. Can you give us any background about how that came to be the case?
So Sydney Water has an agreement for an accelerated development with Celestino. That's not an unusual agreement for Sydney Water to be entering into. With any developer that wants to develop land, what we would describe as, in general terms, out of sequence. And in those instances, the developer will forward fund all of the infrastructure required to service that particular development. And by forward funding, that's both the infrastructure but also the land acquisitions associated with any infrastructure that needs to be built. And then over time, Sydney Water, depending on the appropriateness of and whether those assets serve other developers along the way, will reimburse under our standard policies at a later date once development and customers come online. So basically we're future-proofing our customers from any growth risk, so any infrastructure that's built without customers to use.
Yeah. So so in the first instance, this is a significant investment of water infrastructure. This is a $200 million investment. But are you saying this investment was made by the developer, by Celestino, not by Sydney Water?
That's right.
In the first instance.
That's right.
Yep. And when will, over what time period will Sydney Water start to invest in this?
We've actually started constructing work at the moment. So there's a transaction between the two organisations to pay for those works as they're being built.
Yeah, and what is Sydney Water's contribution by way of that transaction?
Well, we're obviously the intellectual know-how to build and operate those sort of assets.
So what's the total value of that work? It's $200 million in total, is it?
Yeah. Sorry, I'd have to say that I haven't gone and got any detailed notes for this because it's
no worries.
not really within the scope of the the committee.
Well, it is within the scope of this committee. It certainly is. One of the reasons I'm struggling with the evidence you're giving is at budget estimates on the 10th of March, when asked the same questions about that water deal, when it was announced, Minister Ayres said Sydney Water will pay for that. Celestina will probably make a contribution.
I'll have to take on notice that to get some specific answers for you.
But to be clear, that's the exact opposite of the evidence you're giving us.
I understand. I'll have to take it on notice and make sure that you get the answers that you're asking for.
Does that mean you're standing by the evidence you've just given, or are you withdrawing the evidence you've just given?
I think he's taken it on notice.
No, I'm now... No.
Let's have the clarification.
That stands. I'm now asking about the evidence he's given up till now, because...
I gave the evidence as I understood it. If I have misunderstood it, the evidence as I understand, I will have it corrected on the record.
Yeah, okay. No, I think that's fair. I just want to be clear about...
And I understand there was a Standing Order 52 that had been gone through whatever process that was, and Sydney Water has responded to that, and I think the answers would be in that document.
Yeah. Again, one of the concerns is documents available show that on the 3rd of December, Sydney Water's media lead is telling Minister Pavey's office, I quote, Sydney Water is investing around $200 million over the next 30 years to build an integrated water cycle system and associated infrastructure at Sydney Science Park. Well, this doesn't sound like a developer paying for it, Mr Plowman. This sounds like Sydney Water paying for it.
I think I can only say what I said before. I understand the question that you've asked, and I'll take it on notice and make sure the record is correct.
Yeah, okay. Yeah, so I invite you to come back on that information. I might just keep, because I'm going to have to duck off, I might... So I just want to rewind then to, on one of the reasons why this is of some surprise is Sydney Water earlier on had been taking quite a hard line position about this proposal. So this is the Sydney Water view in September of 2015. It describes this site as a proponent-led, out-of-sequence, at no cost to government planning proposal, and advises that Sydney Water has no servicing strategy for the area and would not be funding trunk or lead-in infrastructure for the proposed development. So that's... Now, you've used some of those terms if you've described these sorts of arrangements that might be in place. That's pretty clear-cut.
And that's...
In 2015.
Yep.
Do you agree with that?
I'll have to take the question on notice.
Can you explain why what was a hardline position in 2015 has led to $200 million being invested in 2020 by someone? We'll clarify who. Do you see that as a shift in position?
We have an out-of-sequence policy document for all developers if they want to go out of sequence to have that infrastructure built. I would imagine that statement was made prior to any negotiations or discussions with the developer on how we would fund such an arrangement to make sure that our customers would not be out of pocket for funding out-of-sequence development.
Or provide us on notice with that out-of-sequence policy that you just made reference to?
Yeah, if it hasn't already been tabled as part of the 52...
No, it needs to be tabled in the inquiry. So do you mind doing that on notice?
I'll take that on notice.
Thank you.
Great, thank you. And would that policy normally involve Sydney Water stumping up the cash up front?
As the whole idea is to make sure that customers are not out of pocket.
That wasn't the question.
Yeah, so under that policy, if there's a significant investment, say hundreds of millions of dollars in water infrastructure, under that policy, who stumps up the cash? The developer or Sydney Water? Or is that to be negotiated?
As I said, I'd take it on notice, but the philosophy is that customers don't take the development risk for development, so it's generally future funded by developers. So I will take it on notice.
I'm just struggling to understand what you mean by that. So in general, the developer is paying. I'm asking now about the usual course of events.
Just let me clarify something on this, because I think your terminology of the customers is Sydney Water customers. Is that correct?
Right.
Yeah. So Sydney Water's not picking up the bill, the developer is effectively.
Under that policy. That's how we try to say. That's the general philosophy of what we're trying to achieve.
Yeah, I thank you for that. Yeah, so So is that clear under the policy? The developer would normally pay, not Sydney Water, not the customer, as it's passed on.
Well, I'll take that on notice, and the information I'll be providing, which I've already committed to taking on notice, would have the answers to that.
Do you not know, Mr. Plowman?
It's not my area of expertise. I'm here, as I explained, what I was doing before.
But you were aware that the committee requested that we wanted a person who's in this position
And we read the terms of reference, and it was about acquisition, and I'm here to answer the questions about specific acquisitions.
But you are aware that the committee requested that a person be provided who's in a position to answer these questions about the Celestina development, or your view is that you, as with Sydney Water, disagreed with our ability to do that, and you were sent in someone instead. Is that basically what's happened?
It was decided that I was the most suitable person to attend.
Yeah, and that's a matter for Sydney Water. However, we're deciding what
ask you.
Understood, and I've committed
we're
to,
struggling
and
with
will
your
continue to commit to providing those answers on notice.
Why don't you go?
So, Mr. Plowman, can I just be clear here? There is what's called a in-sequence, or I could only infer if there's an out-of-sequence process, that there is a sequence by which you build water infrastructure for new areas. Is that correct?
Mm-hmm.
Yes?
Yep.
Yep, sorry, you have to verbally.
Yes.
Just for Hansard. Yes, that's correct.
Mm.
And that's planned, is it? Is that strategically planned over what time horizon?
It can vary depending on the areas, but we have a growth servicing plan that we put out for people to see where the sequence of development's happening every so often.
What's every so often?
I don't know the answer to that. I have to take that on notice.
Okay, can we get on notice the plan that applied, the growth plan? Did you describe it as the growth areas plan, or
Servicing plan.
growth servicing plan that existed in 2015, if that's possible? And on the one on notice as well, can we get the one that applies now?
That's all available on our website.
Yes, but can we still ask you to formally provide it as evidence?
That's appropriate, yes.
Thank you. So, out of sequence, just can you explain to me, is when a developer wishes to deviate by bringing forward an area, or for that matter, having an area connected that otherwise wouldn't be connected? Is that fair?
That's correct.
And do you have a policy in place to guide how Sydney Water is to act in that circumstance?
That is correct, and that was
what
I will provide on notice.
Yes.
Yep.
And a developer has a right, or any person who wishes to have water infrastructure put anywhere out of sequence is entitled to come and speak to Sydney Water directly about an adjustment under that policy in broad terms?
Indeed.
And did Celestina come and ask?
To the best of my knowledge, yes.
Do you know when?
No, I do not know when.
Can you take it on notice to find out when?
Can indeed.
And so, is $200 million out of sequence large or small in the scheme of things, in terms of what you described as usual practice?
Our capital budget next year is $1.4 billion, so...
No, I'm talking about for a developer, a proponent under the out-of-sequence policy. Is $200 million a large amount for a developer?
I
or
don't
small?
think you can make comparisons, because it would be different depending on the nature of the development, the distance away
Well,
it
is
was
this a
from
big
existing.
development or a small development according to that policy?
This is a big development.
So you would agree it's a big development, yes?
Sydney Science Park as a general concept, yes, is a big development.
So it's, therefore, for a big development of this size, who in Sydney Water agrees to it? How does it work? Do you agree to it, or is it your job, or is it the CEO? Like, who in Sydney Water is responsible for negotiating with the developer?
Who signs off on this landmark partnership agreement in Sydney Water?
Well, it'll be all part of the usual investment business case process that we have, so within the delegations of the organisation.
Well, who has delegation to approve a $200 million application? Is that
It would be at that level the managing director to spend $200 million worth of capital works would be the delegation of the board, I would imagine.
So the board would have to approve it? Agreed. So it's likely that this matter was considered by your board?
It was
considered?
Yep.
And
Within the policy that I just described before.
And how long does it usually take to negotiate an out-of-sequence agreement of this size? What's the expected? If I was to turn up to your office today and say I'd like to talk to you about a $200 million out-of-sequence development, how long will it take before I get an answer, a final answer?
That could take years.
Years.
Yep.
And
that would depend on the extent and the circumstances of a particular development, where it is, what the developer seeks to achieve out of that development.
Can I just ask, where are we now in relation to this infrastructure? Because it was originally meant to be commenced on December 21st, December last year. Has this actually commenced? Is this infrastructure being built?
Yeah, it's currently under construction.
And how far through the construction process are we?
We would be seeking to commission by the end of this calendar year, December 22.
Yep. So, and did it start on time from your point of view? Did it commence in December 21?
Yes, yeah, as far as I know.
Minister Ayres and Minister Pavey were at that announcement on the 17th of December 2020. Minister Pavey would have been there in her capacity as Minister for Water. Minister Ayres in his capacity perhaps as Western Sydney Minister, do you recall?
I cannot recall who attended the event.
Okay. If you could take on notice any details about which ministers' officers were contacted about the announcement and the terms on which they were contacted.
Certainly.
And I'm going to leave it at that point, I think.
I'm going to continue. So it would take usually a number of years to negotiate of this scale. So can we infer from that?
It could do.
So can we infer from that Celestino would have asked for this a few years ago?
I'd have to take on notice the exact dates.
Okay. Do you have any idea as to... I'm not asking necessarily for the exact date, but although on notice I'm happy to accept it, but do you have any idea as to when it started?
It would have been a number of years.
And
maybe 2 or 3 years, but I will get the exact timeframes.
And what... It's a relatively open-ended question, but what sort of due diligence does Sydney Water follow before it decides that such a partnership is in Sydney Water's best interest? Do you retain consultants? Do you peer review it? Is it just that your internal team produces an analysis? How do you verify?
And what sort of due diligence would you be asking about?
Well, do you interrogate costs, cash flow models? Do you look at payback periods, likely until the work is
Absolutely, but that would be exactly the same for any developer and be part of the investment evaluation decision.
Okay, and that investment evaluation decision is done in-house?
Yes, generally speaking, that is an expertise we have.
And do you use external consultants to verify your work of any fault?
Occasionally, but I couldn't answer whether it was done on this particular project or not.
Can you take that on notice and inquire as to whether it was? Thank you. And presumably, therefore, all that is done prior to the board being informed, correct?
Yes, the board would be involved in various points along the way, but yes, prior to their final decision.
So, can you take on notice when the board approved this partnership?
Yep.
Thank you. Minister Ayres called it...
I should say, yes.
Minister Ayres called it...
It picks up yep, that's all right, don't worry. Yeah.
Minister Ayres called it a landmark partnership. Why is this a landmark partnership?
The actual development is a closed system water cycle, integrated water cycle development. So the way that recycled water will be used and the technologies that we'll be using to serve the eventual customers in there is quite different to what we've usually done. So it's landmark from a technological perspective.
Okay. Mr. Plumman, you said that your best understanding was that this $200 million is being paid by Celestino. So in practical terms, does that mean what, you build it and send them an invoice, or...?
I'd have to take on notice, but
okay.
Exactly the transaction process.
And what, do they pay all the money up front, or they pay it off in instalments, they pay it off over time?
I'll take that on notice to provide that information to the committee.
Okay. And can I ask, in respect to the $200 million, how, do you have to acknowledge a provision or any risk on that in terms of the money that's been provided to you or not? Do you commence work prior, how do you effectively reflect this $200 million contribution in your accounts?
I'd take that on notice.
Okay. Can I ask you, has Sydney Water set up a business development unit?
Yes, it has.
Who leads it?
Chris Gould.
And is there a head of city growth and development?
Yes.
Who's that?
Chris Gant.
And has Mr. Gant previously worked for Celestina?
I believe he has.
And was he immediately prior to him commencing as the head of city growth and development a development manager for Celestina?
I believe he was.
Has that unit played any role in this partnership?
Are you talking about the unit or Christopher Grant?
Well, first the unit.
Of course.
And what about Mr. Gant?
No.
And why not?
Prior to the transaction being signed, I understand that he did not. By the way, I think these weren't these subject to the standing order
Yes,
52, and this has all been answered? I can provide that same information.
Mr. Plowman, for what it's worth, I don't want to necessarily remind you that witnesses usually don't ask questions, but I understand it's been made in good spirit, but Standing Order 52 is about production of documents.
Yep.
Often which is then used to inform the asking of questions and inquiries, which is pretty much exactly what's going on right now. So we as members are entitled to use the documents that we obtain to ask questions of government officials about the matters that arise from them. Is probably the way I would, in terms of a digression as to what we're doing, that's sort of it. So I just return to my question. You said, I'm sorry, I didn't necessarily hear the answer because I think you skipped a bit over it. Mr. Gant, you said Mr. Gant did not play a role in this partnership. Is that your understanding? In the negotiation of this landmark partnership? That
is my understanding.
And why didn't Mr. Gant not play that role?
Because I'd take that on notice.
Was it because he declared a conflict of interest, or?
I believe he did, yes.
And as a result, he was removed from the project? Any involvement with this particular partnership?
He didn't involve him. He wasn't involved in the partnership. Development of the partnership is my understanding.
Okay. But the other parts of the unit did, is that correct?
Yes.
And so that was led by Mr. Gould?
Yes.
So it was Mr. Gould who was most responsible? Is this particular unit within Sydney Water that was the lead in terms of interacting with Celestina?
Yes.
And was that led by Mr. Gould?
Yes.
And what was Mr. Gould's background prior to becoming CEO?
No,
Sorry, the head of that unit.
I don't know. I'd have to take that on notice.
Okay, thank you. I'd appreciate that. Were there any other declarations of interest that were made in respect to this particular project?
Not that I know of.
Yeah, fair enough. Was there a probity advisor at all engaged in respect of inspecting this partnership?
I would have to take that on notice.
What probity checks were what probity checks were in place by Sydney Water in order to assure itself that all policies, procedures and requirements were adhered to?
I'd have to take that on notice.
Okay. Thank you. I think that's it for me.
We were good? All right. Thank you. Thank you very much. I think that brings us to the end of this session. To the extent any questions, well, there were actually quite a lot of questions taken on notice. There's 21 days to respond, but the committee secretariat will be in touch to discuss the process for that. Thank you very much for attending and giving your evidence today, Mr. Plowman. The committee will take a break and we will be back at 3:45 p.m. Thank you. Okay. Welcome back, and thank you very much for attending a little bit earlier than we had planned. That's incredibly helpful for the committee. So we are back with witnesses from Transport for New South Wales. If I could get each of you to please tell us your name and position title, and then swear either an oath or an affirmation. I'll start with you, Mr. Slater.
Thank you. My name is Mark Slater. I'm Executive Director of the Property Group at Transport for New South Wales.
Thank you.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Good afternoon. My name is Jeffrey Allen Cale. I am Director Corridor Identification and Protection. And I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And Ms. Gee?
Hello, my name's Julie G. I'm the Acting Chief Transport Planner at Transport for New South Wales. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much, Ms. G. Would you like to commence with a short statement at all?
Yes, please. Thank you, Madam Chair. We do have a very brief statement.
Please go ahead.
We thank the committee for their invitation to appear as witnesses today. First and foremost, we'd like to state that Transport does not approach potential property acquisitions lightly. We recognise that land and property acquisitions for public infrastructure can be challenging and complex experience for homeowners, landowners, residents and businesses, as well as the Transport staff members who are involved. We acknowledge that when it comes to people's homes and their businesses, property acquisitions can be an emotional time. I would also like to reassure the committee that the property acquisition is only undertaken where there is significant benefit to the broader public. Wherever possible, we look to make use of government-owned land. Land acquisition for essential infrastructure purposes is often an important step in the delivery of critical infrastructure, particularly in light of our state's growing population and government's duty to provide essential services to the community. Transport is currently delivering the largest infrastructure program this nation has ever seen, with $72 billion of investment over 4 years for major city shaping and precinct projects like Sydney Metro, light rail, motorways and road upgrades, delivering benefits for communities for generations to come. However, it is equally important that land acquisitions for these purposes are fair and transparent and contain the necessary checks and balances. The property acquisition process has been improved in recent years to ensure homeowners and business owners have appropriate support and time to make informed decisions and to ensure that they are supported throughout the process. Transport works closely with home and business owners to ensure they receive fair compensation and in accordance with the Just Terms Act. We aim to complete acquisitions by agreement rather than by compulsory acquisition process, which is in line with the recommendations of the Pratt and Russell reviews. For residential and small business acquisitions, Transport will appoint a personal manager to each home or business owner to help support and guide them through the acquisition and relocation process. In June 2019, Transport developed and released new property acquisition standards, which included minimum requirements for hardship assessment and a minimum negotiation period. We now provide clear information on the compulsory acquisition process for impacted residents and have undertaken a capability uplift across Transport for all staff involved in the property acquisition process. The new standards commit acquiring authorities like Transport to improving the experience of property owners by ensuring acquisition processes are fair, consistent and transparent. Transport also implemented 6 of the 7 objectives and recommendations from the May 2021 Auditor General's report, and we completed this by the end of 2021. This ensured our property acquisition processes and policies align with the Auditor General's recommendations and meet the community's expectations regarding integrity, rigour and value for money. Today, I will be offering my assistance with questions regarding the property acquisition process. My colleague, Ms. Gee, will be able to assist with questions regarding the transport planning process and the Centre for Property Acquisitions. Mr. Cale will be able to assist with questions regarding corridor planning in particular. We thank you for the opportunity to make an opening statement.
Thank you. Mr Mookie.
Thank you. I think what we might do, Chair, if it's okay with you, is at first instance perhaps we can deal with the issues to do with transport's engagement with broader acquisitions, and then perhaps we can get to corridor preservation issues in that order, if that's okay. So with this is otherwise it's just slightly two different subject matters. Yep. Yes. First, Mr Slater, you are precisely you're the head of.
The property group within Transport, which includes the team, the land acquisition team that undertakes the property acquisition process.
And that's for Transport for New South Wales, correct?
That's for Transport for New South Wales.
And which part of Transport for New South Wales do you sit within?
That sits within infrastructure in place.
Infrastructure in place. And that the Deputy Secretary responsible is?
Camilla Drover.
Mr Drover, yes. Fair enough. And this was a role or a structure that was recently adopted, is that true?
This was brought about from February 2021 as part of Evolving Transport. I joined in May 2021.
Yep. And Ms G, you were part of that team?
No, I'm not. I'm in the CST division, so Customer Strategy Technology.
Okay.
So under Joost de Kock is the Deputy Secretary. Yep.
Yeah, and equally a structure that's been adopted as a part of the Evolving Transport project.
Strategic Transport Planning is a branch that has been around for a number of years, but it has had some changes recently through Evolving Transport.
Yeah.
So the Centre for Property Acquisition came into it recently.
Thank you. Mr Slater, I might then direct these questions at first instance to you. This committee undertook in one of the earlier hearings into this inquiry examination of the Camellia land acquisition. You aware of that matter?
I am, yes.
And have you by any chance familiarised yourself with the transcript of that time?
I have familiarised myself with that, but I've been focused on the Auditor General's recommendations and implementing those across Transport.
Sure. So, do you want to give us an update as to where you are in terms of those Auditor General recommendations? You said that you've implemented all of them?
There were 7 Auditor General recommendations. We've implemented 6 of them, and we completed that by the required timeframe of December. The one that we were unable to complete was in relation to an internal investigation, and that internal investigation is pending direction from ICAC that they complete their investigation.
Yes, okay. But one of the things that was said at the time was that I think the Secretary told us that there was going to be an audit done, an general audit.
Yes.
Did you do that audit?
Yes, we did.
And what exactly was the scope of the audit?
The scope of the audit was to focus on high value and high risk transactions that had been completed by Transport, and to undertake an audit of whether they had been completed in alignment with the policies, process and procedures, and the necessary governance and assurance of those transactions met the required standards.
And transactions from what period of time?
I would need to take that on record as to what the time frame was, but it went back a number of years, so I understand it may have gone back to prior to Camellia.
Yes. And how many high-risk, high-value acquisitions were identified for that audit?
I would need to take the question on notice as to the exact number of total acquisitions that were investigated and how many of them were high risk and high value, but the specific one of the elements was to ensure that high risk and high value was a key part of the audit.
Okay, well, perhaps what I should do then, before asking you very specific questions, is to ask you to give us a general description of the findings of that audit.
I can give some very much so. So at high level, I understand that there were 50 transactions that were audited, and there were no findings from that audit that indicated that appropriate due diligence had not been undertaken, that approvals weren't in place, and the key areas of risk that were highlighted by the Auditor General in Camellia, which was the focus of the audit. There were no findings that indicated that any transactions that were reviewed from that audit were amiss.
So we can infer that, therefore, that Camellia really was a one-off. Is that fair? Well, I mean, it's just quite clearly Camellia, the audit done by the specific performance audit of the Camellia transaction was, we've described it the Minister described it, well, to be fair, the Minister at the time described it as a disgrace, and we described it as scathing. But we would therefore accept that Camellia was an outlier if you're telling me that the other 50 that were reviewed did not reach a similar conclusion. Is that a fair inference for us to draw?
What I can say is that we didn't find any during that audit, and it was very pleasing to see that the audit that was very detailed and went through a number of transactions in a period that was from Camellia and prior, I believe, right through until 2021, found no instances that were similar in any way.
Okay. In respect to those 50, and I guess any other, one of the second issue that arose in Camellia, in Camellia there were two issues. There was what we paid for it, and then the cost of cleaning it up, and why we didn't know about the full cost of cleaning it up after we bought it. Did the audit touch on land remediation of acquired sites, or was that beyond its scope?
I would need to take that question on notice to specifically covering what the scope was in relation to remediation of sites.
Okay, to the best of your knowledge, has Transport interrogated whether or not there is similar liability on other sites that have been acquired?
What I can say is that when we went through the reform and addressed the Auditor General's recommendations, we have now hard-coded into our process and into our approach around property acquisitions to ensure that all appropriate due diligence is undertaken across all sites, and that fundamentally that has to be signed off and overseen by an appropriate delegate prior to it being able to move forward through the acquisition process. So ensuring that we cannot have a situation that occurred in Camellia where the appropriate due diligence isn't undertaken and completed.
So you now accept that the Camellia deal didn't go through the appropriate due diligence?
I think I can only comment on what the Auditor General highlighted, which was that that was something which you would have expected would have been completed.
Okay, fair enough. So can I just ask you to respond to one of the other things which we've heard in the wake of the Camellia transaction, which has come through from multiple incidences, but including from earlier today. But one of the criticisms has been that, firstly, Transport now never deviates from the valuation reports and panel, and that inference is in order to avoid a situation like Camellia, and it's been described to us as an overcorrection on behalf of Transport. And to be fair, I'm not necessarily sure that's right, but I want to put it to you that there's now a practice in which once you obtained a valuation report, that there's not, rather than that informing a negotiating position, that is effectively defining the limit as to what you would pay. Has that been a practice that you've adopted or Transport has adopted?
Absolutely not, no.
So can you take us through, therefore, what you consider to be normative practice now when it comes to acquisitions of a site?
In relation to evaluation?
Or in general, in brief, but in general, can you take us through how the process and procedure you generally follow now?
I can, very briefly, summarise the very significant body of work that we've just done to actually just uplift and reaffirm the process that was already underway. So when we went through the review that we did, we looked at the current process that was being followed. We looked at other processes, and we've built what we believe is best in class in terms of an approach to property acquisitions going forward. But if there's a specific bit of the process you'd like me to articulate.
Well, is there a policy document now of some form that describes how Transport, the steps and stages that Transport has to follow when it's doing acquisitions?
There is now a Transport property acquisition policy, yes, but there is also a suite of artefacts and some process documents which ensure that the operatives that have to deliver this are really clear on what the minimum expectations are, and the governance and assurance is very clear that has to be stepped through, and also the checks and balances that you would expect us to have for that type of expenditure are now very clear.
Fair. Can you now, on notice, perhaps table the policy and any of the other supporting documents that you just made reference to the extent to which it's possible?
Yeah, we will provide any documentation that we're able to, yes.
Thank you.
And on that point, perhaps as well, what changes have been made since Camellia to those documents, if any?
Yeah, so we did we went through a significant change process through that 6-month period. So we have a number of areas of, what was previously occurring and what the future is. But I think I'll just go back to the key things that were missing in committee, which was, not having a valuation completed prior to, making an offer, not having completed the right level of due diligence, not having the appropriate sign-off. These are all things which are now hard-coded into our process. They were things which, when we did the audit, we did not find, any instances of that happening, and it's, very difficult for me to understand how something like that could have happened, but it is now hard-coded, and it is now something that means that, we cannot have a transaction completing or even getting anywhere near completion without having some key steps being undertaken and key stage gates through the process.
Fair. For what it's worth, if you want to understand how it happened, I guess we could probably tell you, but
I've read.
You might need to wait for our report.
A couple of transcripts.
Can I, Mr. Slater or Ms. G, depending on how you wish to answer this, just turn now to where we're up to in terms of existing acquisitions. So your team is responsible for undertaking Transport for New South Wales' acquisitions?
Correct.
And how many acquisitions are afoot currently?
I can give you a general number now, but if I could take that on.
Yeah, sure. A general number would be good.
We would be doing over 500 live acquisitions, is what I understand at this point in time.
Live acquisitions of interest, which probably describe it, correct?
Yes, they would be multiple, and they wouldn't maybe. We have such a broad range when it comes to substratum, when it comes to interests in land, whether it comes into leasehold interests, but. When I mentioned 500, that would be what I would term more traditional property acquisitions.
Right, number of properties.
Correct.
Yeah, and then you'd have a lot more interests.
And there would be interests on top of that, correct.
Can you just on notice give us a number of live interests to the best of which you can? Just on notice is fine.
Yeah, I'll take that on it, yeah.
And of that 500, is most of them in the Sydney, Greater Sydney Basin?
No.
Okay.
We have the team is spread across the state, and we're working on transactions, on all of the infrastructure projects.
Okay.
So Coffs Harbour bypass and many others.
Predominantly road, though. Do you accept that predominantly road acquisition?
We can give you the breakdown, but it would be a higher proportion of road, yes. But there are others beyond that as well.
Can we get the breakdown between road and rail, and then also the geographic location information to the best that you possibly could that are live? Do you maintain statistics as to how many of them you reach by agreement? How many you reach by compulsory acquisition?
Yes, we do.
Well, what are they?
And we report that through the CPA. So over the last 3 years, it's been 90% or more of acquisitions by negotiation.
90% have been acquired by agreement?
By agreement, yes.
Yes. Okay. And do you know how many of them then escalated to compulsory acquisition?
No. 90% have been negotiated by agreement, and 10%.
So 10% have been done by compulsory acquisition, yes?
Yes.
And then, I guess, of that 10%, do you know how many then appealed to or objections are lodged with the Land and Environment Court?
I don't believe I have that information with me, but it is something that I can take away and come back to you on.
So 90% though is...
It's 90%.
Over what period of time, in the last few years, or...?
That's the information that I have. If you just give me a minute, I'll check, because I believe it's from 2018, 2019, 2020 and 2021.
So since the commencement of Section 10A?
Since as far as the records that I go back, I would need to check. But
well, I think this time period happens to coincide with the introduction of 10A, which Ms G might have info on.
So I think it is from 2017, 2018 to 2020, 2021.
So yes, so from the commencement of 10A, we're at 90%. Yeah. The Chair was asking Sydney Metro earlier about whether or not you maintain any form of data about the feelings of your counterparties after they reach agreement.
Yes, we do.
We do.
Yeah, I mean, I've got a specific, the most recent survey results that we were provided with through the CPA, which is done annually, indicated that I think 6 out of 10 acquisition residents were satisfied but I might defer to Ms G.
Yeah, that's correct. 6 out of 10. So the Centre for Property Acquisitions has a website where all the data is available, and so as part of one of the standards of the CPA requires, or one of the standards that the acquisition process works to, there is a compulsory requirement to seek feedback from every person or party that goes through the acquisition process.
Sorry, is that a legal requirement?
It's part of the standards, the Centre for Property Acquisition standards.
Because could I just ask for some clarification on the Centre for Property Acquisitions?
Yes.
Is that purely Transport for New South Wales?
No, it's a whole of government entity. So it is based within Transport for New South Wales because Transport and Sydney Metro do the most of the acquisitions. But there's about 60 different entities across the state that apply to use these standards, that operate under these standards.
In which case, wouldn't those standards also apply to Metro?
Yes,
It would?
absolutely, yes. So,
do your policies bind Metro by any chance? Or do they make their policies independent of the Transport?
I couldn't really comment on that. I think they are an independent body, but they are part of a Transport cluster. So, Sorry.
What I can say is that the reform program that we went through last year from the Auditor General included Metro as part of the reform. So the policy that was developed applies to both Transport and to Metro, and the process documentation, which articulates how you're to go through the process, was developed with Metro and Transport in mind, and so it applies to Metro as well. There are some small intricacies or certain elements which will be slightly different, but the fundamental premise around the approach to property acquisitions and the process document developed is Metro and Transport's to use.
Okay, fair enough. You were taking us through some numbers.
Sorry.
I think you said 6 out of 10 were satisfied.
Oh, sorry. Yeah, that's right. So I thought you were going back to the property numbers. Yes, 6 out of 10. So that's of all the various property acquisitions that happen across the board. So the property acquisition standards support the Just Terms Act. So there's a number of standards, and one of them is relation. I mean, I can go through them if you like.
No, on notice, if you don't mind.
Sure.
Yep, that would be great. Can I ask then, turn to some specific matters that have been raised. By any chance, did you see the Inner West Council's evidence earlier today?
No.
Okay. So, look, Inner West were quite scathing of you. They said they described you as brutal. They said that you don't talk, you don't negotiate, that each project has a different team, that there's no consistent behaviour by Transport, and that this is creating them tremendous frustration on their behalf. In general, that's my summary of it. Before we take you to the specific incidences, are you aware that they had these concerns?
No.
Okay.
No, and that surprises me.
Well, to be fair to them, it was written out in their submission to this inquiry in quite detail with quite a lot of incidences as to why they have that view. But I'll take you to some of the specifics that they raised. The first is to do with the acquisition of parklands that belong to them, for which they gave us they named 9 parks, which they've interacted with Transport over in recent times. The Transport has taken off them through a compulsory acquisition. Their evidence is that you'd never negotiated on any of them, and that what then happens is that the 6-month period passes, they then go to the Valuer General, who then tends to agree with them, and then if the event that they do not, they then take you to court, for which after they commence litigation, you surrender because you don't want precedents which could be used against you. Is this true?
I have absolutely no knowledge of that in the slightest. So no, I can't comment. I could look at, take a question on notice, but...
Well, they mentioned specifically around projects like the Rozelle Interchange. They mentioned projects specifically around WestConnex. They made some reference to looming fears about the Western Harbour Tunnel processes. This is all going to be behaving. It was quite detailed evidence that they provided, and I don't think I'm being unfair in describing it to you in these ways. Mr. Farlow, I think that's at least what they said, and they may not be right, but that's the way in which they put it. And none of this, you're not aware of any of this.
In the time that I've been in the role, I have not had any escalations from anybody at either within the team or outside the team in relation to engagement with councils. And I suppose there's a couple of things. First things first, the acquisitions team will try and keep expertise and contacts the same. So, and I specifically know, not in relation to that council, but another council where we've got multiple matters going on, we specifically require the same acquisition operators to be involved because they have connections and they have knowledge and they have benefit. It doesn't benefit us to have multiple different people engaging with the same organisation. And I would find it very difficult to believe that anybody in the acquisition team would have specifically put different people into work with a council. There are different project teams, but they're not the people dealing with land acquisitions. We're the only people that deal with land acquisition. So that is something that I will definitely look into, but I find that difficult to understand that, you know, they are saying that they've dealt with multiple different acquisition people. We do have a big team, but we wouldn't be looking to confuse things or not have people that have expertise and knowledge in a particular area, knowledge around a transaction or value or other things, and not have them involved because it makes no sense from an operational perspective for us to do that.
Well, the second, I guess one of the, well, not the second, but another of the major criticisms that they made was even when they do find themselves negotiating with a team, that firstly, it's very hard to get the team transport to turn up for a negotiation was one criticism that they made. Secondly, when they do turn up, transport doesn't negotiate, rather interrogates them for their information and their valuation reports, but isn't prepared to share yours. And then sort of in the same vein of criticism, the language that they used, that the general manager said, he said that he instructs his staff to put on their armour when they have to deal with transport, which is quite startling.
And again, I find that very difficult to understand. And if there are some specifics that we can look to, then I'm happy to look at it, because that is not the experience that I've got through the team. It's not the individuals that I know. It does us no benefit to not try to negotiate. Outside of what's hard-coded in the process and what was in the prior process around, you know, engaging fairly openly and transparently and exchanging valuations and seeking to reach an outcome, which the statistics show that we do, it just doesn't align with what I see as our practice and our approach and the way that we do things. It's completely at odds. So I'd be happy to look into it, because we've got to have, you know, the right relationships with councils, but it isn't something that's come up, and I would have expected, because we have single points of contact in other areas of transport. So within Greater Sydney, they have, obviously transport has lots of engagement with councils on many different things, so we've tried to streamline it and have single points of contact, not for multiple matters, but in terms of escalations. And so I would have thought that if something was happening over the last 6 months that was out of step, that it would have come to me and I would have been made aware of it, that something wasn't appropriate. So if there's some things that we can look to improve, then we certainly will.
I imagine we'll be inviting you to look at the transcript, because to be fair, it was them telling us, and it's their submission that they've put into this inquiry, in which they provided quite a lot of the detail. And to be fair to them, they put the submission in last year as well.
I just want to ask on that. So when we heard from the council that they had at least 2 instances of needing is not the right word, but of taking transport, taking the issue to court or launching court proceedings. And in both of those instances, their evidence was that led to Transport for New South Wales effectively backing down or becoming more reasonable from their perspective. How does that work internally in terms of if there's a team that is involved in making involved in the negotiation, at what point does it get notified to the more senior levels of management in the team? At what point would you be made aware that there might be a risk of a legal action?
Well, the process around negotiation, and if negotiations can't be reached, and then it goes to compulsory, and then if somebody's unhappy with the the VG's determination, and then it goes to the Land and Environment Court and litigation. Depending on the volume, depending on the value and type of escalation is when it will then be notified. So I suppose I'm maybe not being particularly helpful, but
okay.
It's just sort of the process is quite straightforward in terms of, and when we go through it, we have a very prescriptive and very clear kind of approach around what we achieve. We have independent valuations, we have advice around things, and obviously parties can have different views. So, I don't know about a specific instance that's that you're referring to where something's gone to court.
They couldn't tell us because they said that they were bound by commercial and confidence restrictions that were put in place. So, but they told us 2 incidences.
I can just refer back to our current approach. If there's a specific matter that I can take away and respond on, I will.
So in terms of 2 questions. First one is there a mechanism where you could be notified by the acquisition team that the council, for instance, is not happy with what's going on or with the process? Is there a sort of internal complaints mechanism where that would then come up to the higher management?
Yeah, I would be expected to be made aware, and I haven't been in 9 months where, we haven't been able to reach an agreement, and something of a significant nature is therefore then going to litigation. We have to go through the appropriate checks and balances in order to be able to go down that pathway. So it would be escalated up, and it would have a number of different stakeholders, whether it be, from legal or from the acquisition team that would be aware that this matter isn't being resolved, because they're also then linked to timing, often for access for projects. And so these are matters which are, very clear and well known about. They're not things that are happening without the appropriate visibility.
And the second question then is, if something has proceeded to litigation and a decision is going to be made to settle or to basically give a more satisfactory offer of for the acquisition, who makes that decision?
So we have a specific property claims and litigation team who deal with all of those matters to make sure that the appropriate approach and due diligence and review is undertaken.
So they do effectively a cost-benefit analysis where they decide that it's easier to add the value onto the property than to pay for the cost of the litigation?
I'm not aware of their specific operating approach on things, but they are a dedicated and specialist team that are set up to deal with those matters.
Thank you.
Thank you. The other criticism that the council mounted was that upon the return of land, it's not going to be like for like, but equally that the return specifically of open or of construction land that will then be turned into parks results in them not taking freehold possession of the land, but being responsible for its upkeep and maintenance. Is that within your remit, or is that broader transport?
That's broader transport. That would be, I believe, the care and control CCM arrangements that are put in place.
That's not you, though.
That's not me, no.
Yeah, fair enough. Well, we won't pursue that then further on that point. Can I take you through a few other incidences that we're hearing about as well? Can you take us through what's going on with Mulgoa Road? How many properties are you acquiring out there?
Mulgoa Road?
Yep.
I don't know whether I've got that data here, so I could come back to you with the specifics.
Well, again, we're hearing similar criticisms from at least 2 businesses there around the trouble that they have negotiating with transport on the acquisitions of their properties. Are you aware of this? Has any of this been escalated to you?
Not specifically, no. I'm not aware of an escalation in relation to Mulgoa Road.
Okay, you haven't heard from a dental practice and a motorcycle business?
I can come back to you on the specifics, but I'm not aware. No, I mean, there are a number of different matters that are going on, but I'm...
Can you take on notice and find out whether or not you are hearing objections or complaints in that respect? That would be good. Because we have... I was going to ask about an update, if possible, as well, about where we're up to with the WHT Tiger site. Do you know which I'm talking about?
Yes, I do, yeah.
Can we get an update? Where are we up to on that?
My understanding is that we're still waiting for the Valuer General's determination.
Yes, and you've been waiting for a while, haven't you?
We have been waiting for a while, yes.
Yes. And can you take us through what is the impact of the delays in the Valuer General's office having on transport?
We have a number of matters that are pending, there are no, as I'm aware right now, there are no specific matters that are.
But we're told that the Valuer General, according to the Department of Planning and Environment, is averaging 120 days on determination, despite a requirement to resolve it in 45. That's close to 3 times more. In fact, it might be 3 times more than what they should be, and close to 3 times more. That's not having any impact on transport.
It's not what we would have expected, and it's not something that we are monitoring it very closely, even though it's not something that we can control. We're working as closely as we can with them to provide any information up front as part of the VG submissions that we have to make, we're very keen for them to settle as many of the determinations as they can for us.
I'm going to turn to corridor preservation, if that's all right. You go. Thank you. We might turn to corridor preservation, if that's all right. Mr. Carl, what is corridor preservation? Can you take us through? Give us an explanation.
Yes, my pleasure.
Can you move the microphone forward, please?
So, my pleasure. I'm rather passionate about corridor preservation.
Well, you've come to the right place.
Yes. Corridor preservation is about long-term strategic thinking to secure long-term strategic corridors. Those corridors may not need to be built on for 10, 20, 30, 40, 50 years. But the objective is to plan for those now before urbanisation and other developments preclude that future transport from being built, or forcing future transport to plough through homes, which would have major social disruption, or being forced to go underground, which can be some 10 times the cost and may preclude particularly public transport from being built. Corridor preservation hasn't been done at the scale we're doing now since about the 1950s. So back in the 1950s, a number of corridors were identified, and those corridors have largely been built on. The M2, the M7, some of the Northwest Metro, etc. Most of those have been built on already, and there has not been large-scale corridor preservation over some 70 years. So we are now, thanks to some very important strategic documents, such as the Long-Term Strategic Transport Plan in 2012 and Future Transport 2056 in 2017, plus great work done by Greater Sydney Commission and also ratified by a number of councils. Those strategic documents have identified the desire, the need for connection between various centres. So it's been our job to work out how to connect those centres with appropriate corridors. Obviously, with the Western Parkland City and the new Aerotropolis and airport going in, our focus has largely been on Western Sydney. And the work we've been doing is focusing on providing the absolute critical spines and the connectivity for that new city. And we want to protect those corridors prior to the area being developed. That way we can minimise that social impact and get in before houses and utilities, etc. are in there. Some of those key corridors are the Outer Sydney Orbital, which would provide a connection from the northwest residential areas through to the Western Sydney area for largely employment, and also connecting with the southwest residential areas, and ultimately down to the Hume Highway and ideally eventually to the Illawarra. So it's about connecting people. The Outer Sydney Orbital was planned at this stage to be in part a motorway, but also in part a dedicated freight rail line.
That's the M9 we're talking about, the motorway component?
The M9 is the motorway component, but the Outer Sydney Orbital has the M9, or proposed to have the M9 in it, but also very importantly, a dedicated freight rail line. And one of the other corridors we've been working on is the Western Sydney Freight Line. Now, that is a very important corridor for potentially a Western Sydney Freight Line, dedicated freight rail to service Western Sydney, but also very importantly to connect Port Botany with Western Sydney and ideally an intermodal terminal through to the main West Line near St Mary's, and then further west. The primary benefit of that, well, some of the primary benefits are relieving the passenger rail network on the main West Line from freight trains. So you may be aware freight trains currently pass through Parramatta, but you may not be aware that the window for freight trains is diminishing. Because more passenger services means that freight trains are having less time able to be accessing through there. We suspect within 10 years that window is going to be very, very small, and that will have a major impact if we don't do a bypass. Will have a major impact on productivity from Port Botany and across Sydney, across New South Wales.
Thank you, Mr. Carl. Can I ask you just firstly, how legally is a corridor preserved?
Great question, thank you. It depends. We go through a process of looking at those source documents. As I said, the Future Transport 2056 are the regional plans. We do a strategic justification. We go through constraints analysis. We engage with the community, which is very important. We develop long list options. We work through the short list options. We take those back to the community. We then develop a preferred corridor on a strategic environmental assessment. And then, hopefully, that document and that proposal is lodged with Department of Planning and Environment, and we ask them to gazette the corridor and rezone it. Now, not all our corridors have gone right through that process, but when they are gazetted and rezoned, they have a special purpose 2 zoning, which allows us to have a concurrence role and to restrict inappropriate development in that corridor.
Fair enough. I'm about to, that is actually very helpful. I will want to return to my main line of questioning, but there was one, now that you've mentioned it, it might be appropriate to ask this now. Have you designated any land around Narellan as special purpose infrastructure?
Yes.
And is that to allow the construction of a rail station sometime in the future?
Yes.
And how many properties have been affected by that rezoning?
I believe it's 19 properties. That's for what we call the north-south rail line from St Mary's through the airport, through the Bradfield, the new city, and then down through Oran Park. And then from Oran Park south to link up with Macarthur, it needs to go in tunnel, because you may be aware that there's a lot of homes between Oran Park. It includes Harrington Park, Narellan,
there's a lot of homes.
a lot of homes all the way down there.
Is it the intent that that station would be built by and controlled by Sydney Metro, or built and controlled by, I guess it would be the Transport Asset Holding Entity?
Well, look, our job is to identify corridors and to ensure that those corridors can be built. So in terms of the Narellan site, we have asked Department of Planning, and they have rezoned the area around there for what we call a station box, so a station underground, and also sufficient area for us to be able to construct that station box. So that is zoned special purpose 2. In terms of how it is picked up in the design phase and the operational phase, delivery phase, construction, etc., that is beyond corridor preservation. That's a subject for future government to make a decision on.
You as in Transport designated this area as special purpose infrastructure in 2018, is that correct?
We asked the Department of Planning and Environment to do that.
And around that time?
So,
or they did that around...
So we exhibited a preferred corridor in 2018, and in 2020, the Department of Planning sought and was achieved the gazettal and rezoning of that corridor, including that site at Narellan.
So the residents of the 19 and the businesses of the 19 properties haven't heard anything since about the rezoning, or for that matter, the compulsory acquisition, which was also made reference to. Do you know why, by any chance, there's been no further contact with them?
There's two aspects in that. Firstly, the identification of a special purpose 2 zoning for corridor protection is for long-term infrastructure. We are not in the process of compulsory acquiring that land at this point in time. Compulsory acquisition would occur if the government hasn't already purchased it, closer to the time of construction. So it's not compulsory acquisition.
So now these people are effectively in a form of limbo until at some point in the future the government decides to build or not build a station in Narellan.
What we have is a situation where when a corridor is gazetted, there is provision under Land Acquisition Just Terms Compensation Act 1991 for hardship to be declared, and for the government to acquire properties, a person's property, if they can demonstrate hardship under that legislation. So far, we've purchased about 19 properties across the suite of corridors we've identified already. So there is that provision. But can I just go back to your earlier point, Mr. Mookie? We do have consultation, and it's ongoing consultation with landowners. And I personally have spoken with a person there who has been stated to be representing a number of those landholders around the Narellan station. I've spoken to her a number of times and kept her informed of where we're up to.
Okay, well, I'm just going to, before I return to the main line of questions I wanted to ask you about, Mr. Carl, I'm just going to read you this from a media article that appeared about this matter on the 6th of March 2021, which was now clearly a year ago, a little bit over a year ago, a year and 2 days ago. It says here that Transport for New South Wales spokesperson is quoted as saying, the final corridors for the Sydney Metro, Western Sydney Airport, South West Rail extension of the Western Sydney Freight Line were confirmed on June 30, 2020. All impacted property owners have been notified. Then they've gone to say, and this is the key bit, Transport for New South Wales are still working through the cost to complete the future extensions of the Sydney Metro network. Is that work completed?
I can't comment on Metro's
but
processes.
But this is Transport for New South Wales are still working through the cost, not Metro.
I can't answer that. As I said, our task is to protect the corridor, to identify it, get it gazetted, and then make sure it is protected. Once the corridor is there, it's up to a subsequent government to work out the details of design and the timing of the infrastructure going in.
Well, I appreciate that, Mr. Carl. That might not be within the remit of your team, so therefore can I invite either you or Mr. Slater or Ms. G or someone to take it on notice to get a response, because these 19 property owners in Narellan haven't heard a word and they're a bit worried. And it wouldn't be mine if we can get them an update as to what's going on, if anything, particularly around because some reference was made to compulsory acquisition and they are feeling like their assets are stranded.
Yeah. As I said, Mr. Mookie, we don't need compulsory acquisition. And as I've said...
Are you saying to the residents in Narellan now that their properties are not going to be acquired?
Yeah, well, I'm very happy to communicate with those residents. I will have someone in my team communicate with those residents to reassure them. And we'll take that. We'll do that.
Thank you very much. Can I now return, I guess, what I would term my main line of questioning? Mr. Carl, you have been in your role how long?
Good question. I started in 2015, so coming up to almost 7 years, yeah.
Okay, and you have been leading the development around the preservation of land corridors for the outer Sydney orbital, as you described, is that correct?
Yes. Before I joined Transport, the outer Sydney orbital had already been identified in the long-term Transport Master Plan in 2012, and there was a team already starting to look at that project. When I came along, shortly after I came along, we exhibited a study area.
Yeah, I appreciate that.
For the outer Sydney orbital.
But Mr. Carl, the outer Sydney orbital, does it pass through the Sydney Science Park?
It touches Sydney Science Park, yes. It goes between a very narrow gap between Twin Creeks, which is large residential area, the Orchard Hills Defence land, and the land that is designated as Sydney Science Park. There's a narrow gap there, which is directly north of the entrance to the Western Sydney Airport, and in a direct line with there and the M4 and also St Mary's, which we are targeting.
That's the corridor as it currently stands, correct?
Correct.
But previous to that, there were 3 potential corridors that ran through it, correct?
Early on, there's far more than 3. There was a large array of corridors, some going out through Penrith, some all over the place.
Well, in 2014, this might be before your time, but I think you might be aware that Penrith Council asked Transport for New South Wales to comment on a Sydney Science Park development proposal, did they not?
I can't verify that.
And according, I think, to an email that's been produced to the Upper House, a senior planner wrote to Penrith Council and said that there are 3 potential OSL corridors which run through the development site. Determination of the preferred route for the corridor is likely to be 2 years away. The conceptual OSL, or outer Sydney orbital, corridor traversing through the site would sever the development site, and this may have major implications for how the site is planned. Are you aware that communication was made?
No, I'm not.
Okay. So this person is saying, I appreciate that you wouldn't be, Mr. Cull, if you weren't there, right? But this is what's been produced to us, which is at the time, the corridor was going to cut the site in 2, and that would absolutely impact on its developments. That's how I interpreted that email. Are you aware that that was the likely effect of that particular corridor prior to it being shifted to the one you just described?
No, look, there were a number of corridors for the outer Sydney orbital investigated between the time of the study area being exhibited in 2015 and when we went out with a preferred corridor in 2018. There were various versions of the corridor. I'm aware of one in particular which was proposed to come from diagonally from the Northern Road and cut across what we'd call the back part of Sydney Science Park, and then cross the pipeline and avoid the defence land and head north. That option was rejected when it became clear that the Western Sydney Airport wanted access to the main entrance on the northern side, and we didn't want to have a triangle of major motorways and infrastructure. So we consolidated the arrangement so the outer Sydney orbital would overlap with the M12 corridor to reduce the footprint.
We'll get to that point.
Yep.
But this senior planner then reflects on the implications of the Sydney Science Park being split in 2 by the orbital. They said that access to the site and between the eastern and western sections of the site are an issue for the proponent to resolve and fund. They also made the point that there would be a need for noise mitigation to deal with the problem of a severed site, and that became Transport for New South Wales' formal position in response to the Penrith Council request. So that her views were reflected in the position that the Transport then put forward to the Penrith City Council. Yep. You agree that if the 2015 position by Transport, at least as indicated to Penrith Council, had prevailed, that would have split the SSP site in 2 and that would have resulted in some pretty serious impacts for the owner of that site?
I can only go on what you've said. I can't verify it. I haven't seen the papers. But can I just say, you need to look at the timing around all this. I'm aware that in mid-2015, the then Minister for Planning, Minister Stokes, was out on site endorsing a rezoning of the Sydney Science Park.
Yeah.
And I understand the rezoning of the Sydney Science Park was done by Council in about October 2016. Around that time, in 2015, we went out with a very broad study area. And we sought input from all stakeholders, and Celestino, the owners of Sydney Science Park, I recall, made representation, and that would have been one of the factors we would have considered, because the objective of corridor preservation is to provide connectivity without destroying development and homes, etc. So we would regard Twin Creeks, the residential area, and existing and well advanced commercial development or other sensitive land uses as constraints, and we would endeavour to minimise our impact on those constraints.
Mr. Cole, trust me when I say we'll get to all that.
Okay.
Rest assured. But as you rightly point out, at the time, the then Planning Minister, Minister Stokes, was out publicly supporting the rezoning of the land to facilitate the construction of the SSP. That's fair, and that's on the public record.
Yes.
Did that create any concern for you?
As I said, that would be one of the factors we would consider. That the corridor preservation is an exercise of balancing a whole lot of issues, constraints, and values.
Mr. Cole, the question specifically, at the time, the fact that the minister was endorsing this this proposal prior to you having completed the corridor preservation, did that cause you concern?
Concern is probably the wrong word. It was, as I said, a factor considered, and our objective with the Outer Sydney Orbital was to reduce the impact on residential areas and commercial areas. If I can just say, also around that time, Infrastructure New South Wales were undertaking a business case looking at South Creek, and they encouraged us to utilise the South Creek corridor, primarily because the Outer Sydney Orbital would be in viaduct along South Creek, and land acquisitions would enable the South Creek area to come into government ownership. So the alignment that we have squeezing between Sydney Science Park and Twin Creeks also took advantage of that request from New South Wales to utilise more of South Creek.
Okay, but Mr. Carl, do you recall writing an email at the time, in fact, the 30th of October 2015, to, I think it was a person by the name of Mr. Raymond, that expressed some concerns around the minister's position?
I don't recall that, but Mr. Tim Raymond was my manager, my boss at that time.
Your boss at the time, okay. Well, do you recall specifically writing him an email in which you said, the Sydney Science Park has been endorsed publicly by the Minister for Planning, Stokes. The SSP plans would not be showing the OSO, which I think is a reference to the Outer Sydney Orbital. Our options impact on Sydney Science Park to varying degrees, and if our options impact on SSP to varying degrees, and if the SSP plan goes out before the OSO plans, then it would look like one part of the government, Transport for New South Wales, is trashing the plans of another part of the government. Do you recall saying that?
I don't recall that, but I wouldn't step away from that comment.
Sure. And look, to be fair to you, it's a legitimate concern, right? Because at the same time that the planning department is sponsoring, or the minister is seemingly in favour of this particular proposal, Transport, it's not aligning with Transport's view at the time. Is that a fair inference?
It was as I said, it was a constraint. It was a matter for consideration.
Sure. But then you went on to say, if we were able to talk to SSP about our plans, then the SSP plan, or at least the media around SSP, could state that they are in negotiations with Transport for New South Wales about the OSO alignment. So what's the way in which you were intending to resolve this apparent conflict was to seek a direct dialogue with the Sydney Science Park?
I don't quite follow what you read out there. However,
well, let me repeat it to you.
As I indicated, the way we do corridor preservation is to identify constraints and opportunities.
Let me just read it to you again, and I'll give you what I infer from it. And given you were the author of it, you tell me whether that's right or wrong. But it says here that you suggested if we were able to talk to Sydney Science Parks about our plans, and the Sydney Science Plan, a park plan, or at least the media around SSP could state that they are in negotiations with Transport for New South Wales about the OSO alignment. It sounded like you were giving them an option, and it was a solution to the particular issue, namely that there was a conflict between the view that was being favoured by the Minister and the view of Transport for New South Wales at the time, and then at least allow you to be able to or at least the government to be able to deny that there was a conflict by simply saying we were talking to the proponent of the plan to see if we can reach an alignment. Is that the appropriate way to interpret this or not?
The way I would interpret that is that I think I was seeking permission to have those discussions with the Sydney Science Park.
To be clear here, you've then formally asked the then Deputy Secretary of Freight Strategy and Planning, Miss Gardner-Barnes, and then the road ministers to talk to SSP on a confidential basis to arrange the delay in exhibition and the inclusion of a statement that we are in negotiations. The matter is subject to CIC confidences, which I think is commercial in confidence. So you did actually seek approval to have a private dialogue with Sydney Science Park, is that correct?
That certainly sounds like it, but
Did you get the approval?
I don't know, but I would probably assume I did, because the way corridor preservation is undertaken, we try to identify all the constraints and opportunities. Once we went out publicly with the study area, there are a number of private developers, landowners, community members who wanted to talk with us, and we did. We try to have as transparent approach as possible within the bounds of probity, and to understand what those constraints are and understand what the possibilities are for us to be able to reserve a corridor. Sydney Science Park in that instance was one of those constraints, and it sounds like from that email, and I take it on face value, is myself seeking permission to have those discussions with Sydney Science Park.
And let me just be very clear, Mr. Carl. I'm not suggesting that there's anything inappropriate with that as an option. I'm just trying to get your account of what happened.
Yeah, sure.
That's all. And did you? I also then presume that you got the approval. Did you have those meetings with Sydney Science Park?
I recall a number of meetings I had with Celestino, who was the
proponent.
The proponent.
And what was discussed?
All our discussions with developers and any stakeholders is recorded in Consultation Manager, which is a secure database. I would have to refer to what was lodged.
Would you like to take that on notice?
Happy to take that on notice. And if it helps you, Mr. Mookie, I'd be happy to get a copy of what you have in front of you.
Yeah, look, again, to be fair, this is a summary that's been prepared by another member, so I'd have to seek their permission.
Yeah.
But these are just documents that I think have been produced to the upper house.
Okay.
Is the source of it.
Yeah,
well.
I'm taking you on trust there, but it does sound familiar, but I don't recall every email I've ever done.
Look, who does really? But that's why we preserve
that's why we have standing order 52.
and produce them to the upper house. That's right. That's what we're here to check.
Remind us all.
But I'm fairly positive that my colleague, Mr. Latham, might be in a position to provide you with the materials, or primary materials, if you so wish. I don't think there's any objections, but Mr. Latham would have on that. But I'm not sure I can take a question on notice, but nevertheless.
Give it a go.
I'll try it. No one's ever tried that before. But look, to continue on with the narrative here, Mr. Carl, the suggestion then to move the corridor to what ends up being its alignment, was that raised in those meetings those direct meetings you were having with SSP as one potential solution to this?
I'd be very surprised if we spoke about what our plans were. Most discussions with developers, community, residents, etc., is to understand their views.
But to be fair, I wasn't asking you whether or not you put that as a solution. I guess now I'm asking you, did they put that as a solution to you?
I do not recall if they did or not.
Okay, can you take on notice and check the records that you referred to earlier to see whether that's the case?
Yes, certainly.
But then, see, do you send this email on the 30th of October 2015?
Which I don't have, unfortunately.
Yeah, fair enough. But by the 3rd of November 2015, at least according to a document that's been produced to the upper house, Deputy Secretary Barnes approves a memo from Mr. Hunter, Simon Hunter, to advise, I believe authorises him to advise Penrith Council that the SSP site is impacted by corridor investigations, and it would be the preference of Transport for New South Wales for Council not to proceed to the public exhibition on the SSP until the broad options for the OSO and something called the SWRLE, which I think is the South West Rail Line extension, have been placed on public exhibition. However, if Council did wish to proceed with a media exhibition, then it should be acknowledged there may be potentially significant impacts on the site layout from the Outer Sydney Orbital and the South West Rail Line extension that may trigger a need for re-exhibition. Did you suggest to Ms. Barner that she issue that?
I do not recall that.
Yeah. But to be fair to Ms. Garner, like that would be appropriate to provide notice that there might be a conflict between the two, and effectively we should preserve the option. There's again no implications.
That would be, I assume that would be my advice, yes.
Yes, and so, but that takes place within 4 days of you sending the original email, at least according to this timeline. That's pretty fast, or not? Or you are basically, you're a fast mover, are you?
Always. We have to be. Even though we're dealing with long-term strategic corridors, it's a very movable environment. We have to.
It sounds quite exciting. But Penrith Council goes on to proceed with the public explanation. Yeah, and that's what happens. But then, do you recall receiving communication from a representative of Celestino on the 11th of December 2015, in which they outline a position that was adopted by Celestino, and the position that apparently that they suggested that you might wish to consider was to move the outer Sydney orbital routes away from the Sydney Science Park, primarily through the defence land at Orchard Hills to the north of the SSP. Specifically, the communication that I think you received said there would be great merit in discussing the matter with the Federal Minister for Defence, who is aware and supportive of the SSP project, and we are happy to keep working together to resolve the best option for the OSL rail line and SSP. Do you recall receiving that representation from a lobbyist of Celestino?
I do not recall that piece of correspondence.
I'll just give you the name of the person, just so you can check, if you don't mind.
Sure.
I think it's a Mr. Spinack, Jeremy Spinack. Do you recall? I think the late Jeremy Spinack. But
yes, I believe he has passed away. He is a person that I did speak to a number of times during that period. Just as spoke with a number of other landowners and developers, and we received various correspondence from a whole raft of people, and those pieces of correspondence all assisted us in identifying constraints and opportunities.
And look, to be fair, there's nothing untoward about a suggestion that a proponent can have, that everyone has a right to put a view.
Yes.
I'll be very clear of that. But can you check whether you specifically recall receiving that? Do you also recall receiving a representation from the member for Castle Hill at the time, Mr. Williams, Ray Williams, also encouraging you to move the site, I think, to the north of the SSP for the OSL route using the defence land? Actually, to be fair, sorry, Mr. Carl, that representation was made to the then Minister. Did you by any chance see that, or was that given to you?
I can't verify that. However, what I can say is a lot of stakeholders, including members of Parliament, made submissions or provided us with information on their views, and that was put into the mix to help us make decisions. But can I just go back to your earlier point about the Orchard Hills defence land? At various times we did make contact with Defence. I can't say it was in relation to the correspondence you're referring to. But at times we did look at options going through the defence land. And you may be aware of two factors with that. One is it has a lot of very sensitive vegetation on it. And secondly, even more important, it is used for live firing. And there's not an ability to go through that Orchard Hills land other than just very, very minor on the side. So those options which aim to go through the Orchard Hills defence land were fatally flawed.
Okay. Thank you. That's helpful. But just to return again, I guess, to the aspects of the chronology here, in March 2016, did Transport for New South Wales retain as consultants AECOM?
Yes. And
did they undertake a detailed route analysis?
Yes.
And did that also account for the public consultations?
AECOM was engaged prior to myself coming into the team. They were engaged to look at the engineering components primarily of the outer Sydney orbital. They provided a strategic environmental assessment, and they looked at all the options and shortlisted those. In terms of the community consultation, that was run by Transport,
okay.
And AECOM, along with other consultants involved, were involved in the consultation process.
To the options that AECOM shortlisted, what was their preferred option?
Well, the option exhibited in 2018 is the preferred outer Sydney orbital alignment.
Yeah, fair enough. And is that the option which would bifurcate the SSP site?
The current preferred corridor, as I recall, takes off a a piece of the
northern part.
The eastern part, really, of the Sydney Science Park, because what we are trying to do there is fit it between the Twin Creeks area and Sydney Science Park. So that corridor takes out some of the Twin Creeks property, a few holes of golf course, and it takes out a bit of the Sydney Science Park.
So, sorry, that's a good point, but you're saying that right now the current one is the preferred option is the eastern corridor, or what was described as the eastern corridor? Or the eastern sort of...
Yeah, it takes off a slice off the eastern component of Sydney Science Park.
Okay, fair enough. Can I ask then, was RMS at the time, was that who was doing this?
They kicked off the Outer Sydney Orbital work. They engaged ACOM. And then when I came across into transport, we took over the running of the Outer Sydney Orbital project.
Okay, and then as they prepared some papers for a Western Sydney infrastructure interface workshop, did RMS say that at present Transport for New South Wales is undertaking a corridor preservation exercise for the Outer Sydney Orbital, and the expectation is that a Western OSO alignment would be recommended to government by the OSO project team in March 2016?
I'd have to see the correspondence. I'm not aware of what you're talking about.
Is the Western OSO alignment the option that was chosen?
I haven't heard of that being referred to as a Western.
Okay, fair enough. On the 4th of May, Mr. Cole, did you email a Mr. Ian Matthews and a Mr. Trevor Townsend when you CC'd of Mr. Spinak and a Rania Zahab, who I believe was a communications official to yourselves, to say Jeremy Spinak has just phoned and stated that their preferred option is for the OSO to go along the eastern alignment rather than across the western northern alignment. He also said he's flexible with the rail line location, and we agreed to talk again in a couple of weeks and meet up again before any announcements. Do you recall communicating?
I don't recall that, but that makes sense. Mr. Matthews was the project director, or project manager for the Outer Sydney Orbital. He was engaged by the RTA, or Roads and Maritime Services, at the time. So he was running the Outer Sydney Orbital project when I joined, and Trevor Matthews was looking after the rail component.
Basically, by this point, it seems like Transport had effectively agreed that when it comes to the Outer Sydney Orbital, the Celestino option was their preferred option too.
No, I beg to differ on that. As I said, corridor preservation involves trying to get a balance between a whole lot of competing values and interests. Residential areas are of utmost importance, as is commercial and industrial precincts, as well as environment, engineering components, etc. I regard inputs from Sydney Science Park and others as an input into the decision-making process.
Sure, and I'm not suggesting for a second that the predominant motivation of Transport was to suit the requirements of that, but there seems to be a remarkable alignment between the inevitable outcome, or actually the outcome that resulted from this consultation and the position adopted by the Sydney Science Park proponents. They eventually did align. You agree with that?
The option which is the preferred option, which was exhibited in 2018, aimed to minimise impacts on constraints and maximise opportunities. And the alignment through that area impacts in part on the Twin Creeks residential development and in part on the Sydney Science Park. It is aiming to have the most palatable alignment through that area.
But regardless of whether or not I accept at face value what you're saying, that Celestino's input was just one of many, but the outcome that was reached by Transport certainly prevented the Sydney Science Park from being bifurcated in two, as was originally the concern of the proponent, correct?
Look, I believe that the final preferred alignment through there gets a pretty good balance between impact on the residential area and on...
Mr. Carl, the specific question I'm asking you is the position that Transport inevitably eventually adopted here prevented the Sydney Science Park from being split into two. That's correct.
Well, that's a statement of fact, yes?
Yes, thank you. And that did preserve the value of the site for the proponent. You would agree with that?
It minimised the severance of Sydney Science Park. But can I also draw your attention that, as we spoke earlier, the Orchard Hills Defence Land is immediately north of Sydney Science Park, and when we did our inquiries there, it was found that it was fatally flawed to put the outer Sydney orbital through that defence land, and that consequently pushes the alignment back towards the east.
Okay, we don't have much more because the chair is scolding me here. To be fair.
Came here early and Daniel's got to keep you.
But I actually don't have that
Thank
many
goodness, Madam
questions.
Chair. Thank you.
But you accept, Mr. Carl, that without necessarily, well, certainly, I accept that it wasn't transport, well, your evidence on face value that wasn't the purpose of the consultation you were doing. But you have to accept that as a result, the inevitable outcome did confer a benefit on Celestino in that the value of their land was otherwise reduced, as it would have been if the original plan had gone ahead.
Well, yes, but just as likely if we'd chosen to go further east straight through the Twin Creeks residential area, the value of residential area of Twin Creeks would have been greatly diminished.
Yes, but to be fair, Twin Creek residents, well, are you suggesting that the position of a Twin Creek resident is identical and equal to the position of the science park proponent?
Look, that's a value judgment.
Exactly.
But as I said before, residential areas, existing residential areas, and residential areas which are well advanced in their planning phase, of utmost concern to us. We endeavour at all possibility to miss those residential areas because of the social disruption that would be resultant.
But the final route does actually pass next to the Twin Creeks residential estate, doesn't it?
It passes through the part of the estate, yes.
And so those people, in the event that this corridor is inevitably developed, are likely to suffer some diminishment in the value of their land?
We are aware that there would be some potential impacts if mitigation measures were not put in place, yes.
So it is the case that the Twin Creeks residential estates, or at least those to the east of it, are likely to suffer an impact as a result of the decision to move the orbital closer to their properties?
There'd be some direct impacts on the Twin Creeks estate, as there would be some direct impacts on the Sydney Science Park estate.
But not as much under that.
Look, as I said before, corridor preservation is all about getting a balance between values and trying to minimise impacts on people's homes and their livelihood. The preferred corridor that was exhibited, I think, does a reasonably good job at balancing those impacts.
But throughout this process, it was rebalanced in terms of the impact on property owners. It seems like it was rebalanced away from Celestino towards Twin Creeks. And you might suggest that that's reasonable, but that, from what we're observing, the position as it applied in 2014 versus the position that was adopted a few years later certainly did rebalance, that's correct. But the beneficiaries of that rebalancement seems to be Celestino, and the people who did not benefit as much were perhaps the Twin Creek residents.
I would not accept that premise. I think a closer look at the alignment through there, I'd have to check, but I would have thought Twin Creeks would have been affected further to the south as well. So, I'd have to...
But you don't dispute that
I'd have to check that.
Celestino is less affected than it would have otherwise been in 2014.
There are options that the outer Sydney orbital corridor could have taken, which would have been very detrimental to Sydney Science Park. There's other options which could have been very detrimental to Twin Creeks. There's options which could have been very detrimental to a number of other areas. As I said, some of the early corridors had it going up through Penrith. That could have been very detrimental. The idea of corridor preservation is trying to get the right balance between constraints and opportunities.
No minister ever spoke to you about this, is that correct?
Pardon?
No minister ever spoke, or their office ever spoke to you about this?
I don't recall, no.
Can you on notice check whether you had any communications with any minister or ministerial office about this matter?
Yes, we can check our consultation manager database.
Thank you.
Thank you. Right, well, that was very generous of you to give us a little bit of extra time there. Thank you very much. That does conclude this part of the hearing, but also the hearing for the day. In terms of questions taken on notice, you'll have 21 days to return them, but the committee secretariat will be in touch to arrange that. Thank you very much to the committee team and to Hansard. And that concludes. Thank you.
Thank you very much.